To begin the colloquium, may I now request Honorable Mr. Justice Subhasis Talapatra, the Chief Justice, High Court of Orissa, and the cynosure of this occasion to kindly adorn the dais. And I also request the Registrar General, sir, to kindly conduct his lordship to the dais. My lord, please. May I also request Honorable Mr. Justice Sangam Kumar Sahu, Judge High Court of Orissa, and Honorable Mr. Justice Murahari Sri Raman, Judge High Court of Orissa, also to kindly adorn the dais. And may I request respected Member Secretary, sir, and Registrar Vigilance, sir, to kindly conduct their lordships to the dais. Thank you, Lord. May I seek the kind permission of the Honorable Chair to declare this colloquium open? Obliged. With permission of the Honorable Chair, the colloquium is declared open. May I now request Honorable Mr. Justice Murahari Sri Raman, Judge High Court of Orissa and member Odisha Judicial Academy and Training Committee, to kindly deliver the welcome address. My lord, please.
Namaskar. Very good morning to all. Honorable Mr. Justice Subhasis Talapatra, our Chief Justice, and Patron in Chief, Odisha Judicial Academy. Honorable Mr. Justice Sangam Kumar Sahu on the dais. Mr. Justice K.R. Mahapatra, Mr. Justice Miss Justice Savitri Rathod, and honorable judges who have joined virtually, Registrar General and the registry, other officials, district judges, and chief judicial magistrates present in this august gathering, judicial officers who have joined through virtual mode if they have joined, additional director, Odisha Judicial Academy, and his colleagues and the team who have organized today's event. It is with great pleasure and honor that I stand before you today to welcome you all to this esteemed colloquium, Administration of Justice, the District Judiciary, involving judicial officers. This event marks a significant milestone of our legal system through direct interaction program meant for administration of justice in the district judiciary. First and foremost, I would like to express my deepest gratitude to all the district judges and other judicial officers being part of today's event. Your presence is a testament to your commitment towards upholding the rule of law, and your participation in this colloquium would ensure justice for all. Your dedication and expertise are invaluable assets to our society, and we are privileged to have you as pillars of our legal system. This colloquium has been organized with the aim of fostering dialogue, sharing knowledge, and promoting collaboration among judicial officers to provide for a unique platform for exchanging ideas, discussion, emerging challenges. Moving forward with this avowed objective, on this auspicious day of Vishwakarma Puja, I take this great privilege to welcome Honorable Mr. Justice Subhasis Talapatra, our Chief Justice and Patron in Chief, who has inspired us to have this event of present nature, and his presence and guidance will show us the roadmap for setting the role of judicial officers in interpreting and applying the law impartially. With His Lordship's guidance, we indeed have this wonderful opportunity to deliberate upon various pertinent issues relating to administration of justice in the district judiciary. I extend my courteous and warm welcome to my esteemed sister and brother judges of our High Court for making their presence here today, both physically and through virtual mode. Your presence encourages each one of present here for the discussions and sharing experiences. The sharing of collective wisdom and expertise in this August gathering is unparalleled. And by harnessing our collective knowledge, we can address the challenges faced by our legal system more effectively. I, being member of Odisha Judicial Academy Committee, cordially welcome all the respected district judges, chief judicial magistrates present here today on behalf of Odisha Judicial Academy and High Court of Orissa. I sincerely appreciate your that you have taken pain to travel long distance to participate in the colloquium. I also welcome the Registrar General and officers of the registry of our High Court, judicial officers present through virtual mode, and officials of the Judicial Academy. I would like to extend my heartfelt appreciation to the organizing committee for their efforts for getting this remarkable event happened on this auspicious day of Vishwakarma Puja. This dedication and meticulous planning have ensured that this colloquium is a resounding success, with voices of esteemed speakers who would share their insight and expertise with us. Thank you. Thank you very much. Thank you for being with us today. I welcome you all to this event. Thank you.
Thank you, madam, for the warm welcome extended. May I now request Honorable Mr. Justice Sangam Kumar Sahu, Judge High Court of Orissa, to kindly explain the aim and objective of holding this colloquium. Hello, please.
Good morning, Honorable Chief Justice Subhasis Talaputru, Patroning Chief, Odisha Judicial Academy, my esteemed brother Justice Murari Sriraman on the dais, my esteemed sister, brother judges of Odisha High Court of the dais, learned Registrar General and the members of Registry of Orissa High Court, learned district judges and chief judicial magistrates of different districts who are present in this beautiful auditorium, Director in charge, Odisha Judicial Academy and his team, and learned judicial officers and other members of Judiciary who have joined us through virtual mode. As my brother rightly pointed out that today is a very auspicious day as we are celebrating Vishwakarma Puja. Vishwakarma, you know, is the divine architect of Devas in contemporary Hinduism. As a mark of reverence, a day of worship is marked not only by the engineering and architectural community, but by artisan, craftsmen, mechanics, smiths, welders, industrial workers, factory workers, and others. The pray for better future, safe working condition, and above all, success in their respective field. Chief Justice of India, K.G. Balakrishnan, has once said that the role of judiciary has become more meaningful than ever in social engineering concerning the common man and the community. This is so because it has continuously strived to protect the fundamental rights of the citizens and has not wavered from its path of upholding the rule of law. Social engineering is based on the theory that laws are created to save the society and regulate the people's behavior. It's an attempt to control the human conduct through the help of law. Organizing this colloquium on this auspicious day was the brainchild of our Honorable Chief Justice. I'm extremely happy that on this occasion I got the chance to have interaction with you and particularly to address you on the aim and objective of holding this colloquium. Just a few days back, after being designated by the Honorable Chief Justice as the administrative judge of Khurda Justice, I got the opportunity to have an interaction with the learned district judge Khurda, other judicial officers of Khurda Justice, learned public prosecutor and other prosecutors, president and other office bearers of different bar association of Khurda Justice to virtual mode in one platform, that in the presence of IG Crimes, DCP Bhubaneswar, and Director of Public Prosecution. Honorable Chief Justice was kind enough to grace the interaction for some time. The purpose was not only say hello to them, but also to congratulate them for the hard work which all of them are doing in their respective fields. And further to remind them what more duties are there to be performed in a collective way, keeping coordination between the stakeholders so that there would be quick disposal of cases, particularly backlogs should be cleared, and people will appreciate the efforts of the judiciary. Most of the judicial officers of my state are very punctual, sincere, hardworking, and they are keenly interested to grow themselves to better judicial officers and to take more and more responsibilities which are likely to come in the future. Technologically, our state judiciary is far ahead from other states, particularly in view of the development made in the last 2.5 years under the patronage of our ex-Chief Justice, Dr. S. Muralidhar. Our present Chief Justice, Mr. Subhasis Talapotro, is also very sincere to see the progress goes on, and the quality of dispensation of justice improves. He has come here to the land of Lord Jagannath with a mission, and we all hope that he will achieve it, and under his dynamic leadership, Orissa Judiciary would march far ahead. There cannot be any denial that even though the district judiciary and in the High Court, the disposal rate of cases are improving day by day. But Old cases of 10 years above are huge in number, pending in different courts. When I got the list of pendency of cases in different courts of Khurda Justice, I found that there are cases which are pending in some courts for more than 25 years. I told the judicial officers that for this situation, we cannot blame a particular individual, because many presiding officers, many public prosecutors, many advocates must have dealt with those year-old cases from time to time. I suggested a few things to them as to how to tackle the problem, how with the assistance of police, the attendance of the witnesses can be secured in time. The warrants against the absconding accused can be executed. The case should not be delayed for examination of official witnesses if the evidence is recorded through virtual mode. How the court is required to check lengthy and unnecessary cross-examination as well as argument. How to follow section 309 CRPC while granting adjournments in criminal trial. How to take recourse to section 299 CRPC to record evidence of witnesses in absence of accused. How to collect the list of material witnesses at the first instance from the public prosecutor or additional public prosecutor or assistant public prosecutor after the charges are framed. I also suggested to the public prosecutor and APPs not to examine repetitive witnesses on the same point. Honorable Chief Justice also guided them and told them to take recourse to 294 CRPC in marking the documents on admission at the first instance so that examination of numbers of witnesses would reduce. It is, of course, true that due to shortage of judicial officers in some stations, some courts are not functioning since long, and it is creating heavy workload on other courts. And that may be the reason for the courts becoming liberal in granting adjournments when the advocates file time petitions. But one thing is sure, that unless the judicial officer has the knowledge of effective case management as well as court management and how to adjust his time, how to post different cases, he would face extreme difficulty in achieving his target. If one deals with, I do not know, cases to achieve this target for the months, and once it is achieved, he sits idle, neither he will get satisfaction, nor anyone, wherever he is posted, would remember his contribution. I hope today's interaction would be a fruitful one, and it would be helpful in the administration of justice, and the purpose for which this colloquium has been organized will definitely be successful. I would request all the judicial officers, while discharging their duties, to take care of their health, to do regular exercises, yoga, pranayam, spend time with their respective family members, friends, and relatives, and spend some time at least once in a week to pursue whichever field they have in interest, like music, painting, writing poems, reading good books, which should definitely relax them and always keep them in a positive state of mind, which will help them in performing their duties in a better way. I pray Lord Jagannath to give you all peace of mind and happiness, and all of you achieve your goals. Thank you all. Bande Utkal Janani.
Thank you, my lord, for vividly explaining the aim and objective of this colloquium. May I now request my lord, Honorable the Chief Justice, to kindly give the inaugural address. My lord, please.
A very good morning to everyone. My colleague Justice S.K. Sahu, Justice Murahari S. Raman, Justice K.R. Mahapatra, Justice Savitri Ratho, and Justice Shashikant Mishra, and my dear district judges, Chief Judicial Magistrate, Registrar General, the other registers, Member Secretary, Legal Services Authority, Director, Orissa Judicial Academy, and other officers from the registry. At the beginning, I must tender my sincere apology to you all that I personally do not like to encroach upon your holidays. But I have a very short tenure. I will be leaving in the next month, in the very early next month. I have worked in this judiciary for more than 1 year now, and I have observed certain things. Something is very outstanding so far as performance is concerned. Generally, scale is very high. I have no comment on that. But certain things which actually appear to me is not very healthy sign. Healthy sign in a way, not that you have contributed to that trend, but these currents are taking over all your good work. And that is the reason I wanted to have a dialogue with you. Colloquium, I actually requested the Judicial Academy not to break the format. Just talk. Colloquium means a dialogue, and dialogue cannot be the one-way conversation or one-way speeches. It should come from that side also. And that is very important, what you tell to us. When you tell about the problems, recently you are observing, at least in 3 judgments, the state of Orissa, particularly its judicial institution, was under serious criticism by the Supreme Court. If you work, if you take a decision, if you give an opinion, there can be different opinion. Superior Court may not like it. That doesn't concern me at all. When that opinion was formed with all sincerity, even with your best sincerity, knowledge, you form an opinion that may not be approved by the Appellate or Revisional Court, or for that matter also by the Supreme Court in some cases, when your judgment or opinion is affirmed by the High Court. These are the part of our judicial life. But what is more important that I have noticed, that all judges in all districts following the same pattern. And where from the patterns come? Patterns come from the High Court. Unfortunately, High Courts only try to give you certain guidance, share certain experiences, share some best practices from the other jurisdictions, or maybe from the, in view of the various judgments of the Supreme Court. First, I would like to refer to Article 235. I think all of you have read this particular article more than 100 times during discharging our duties. There is a little difficulty I'm finding in the state. What is the purpose of the Article 235? I think most of you started believing that High Court will give us guidance in all the matters. Read with a forensic eye this article. This is a unique article. It segregates the district judiciary from the High Court. This is number one. You must realize that. But in certain matters, it specifically provides that High Court exercises certain control over certain issues so where the district judiciary is concerned. And I must say, this control not at all over your judicial function. This article has been incorporated in the Constitution with a primary object to maintain the independence of the district judiciary. Because in our country, every district has its own phenomenon, own nature of problems. Even some district there is different justice tradition which comes to the court. Some customs, some customary rights you decide. Even in the country, there is no other district which is having these customary rights. So it's very unique. Country was seen as a diverse country, and diversity is only reflected in a district as a unit. We call it the bedrock of the Indian judicial system. A survey done by the BD, the 80% of the litigants of our country never approach the higher judicial institution, meaning the High Court and the Supreme Court. Out of the 100 litigants, the last court is the district court. 80% of the country, who are they? They are definitely not as rich because the 20% is the profile is studied, you find they are rich, they can go to the Supreme Court. That is where I should urge upon you. Our compassion should play to be very careful so that the justice is not protracted. I'm giving you one example. It is the Ministry of Justice survey shows. Throughout, it is an average. It may be more, I think. Then when a case is adjourned, litigant pays the cost, not the formal cost, for his coming to the court, talking to the lawyers, on an average 500 rupees. And with that 500 rupees, if he's an agricultural laborer, if he's a farmer, if he's an industrial worker, he has to sacrifice his one day's wage also in some cases. Therefore, my first request would be, is a two-pronged request, that while granting the adjournment, please exercise your strong authority. I know initially there will be certain repercussion, but when the order in the court will be established, the lawyers and every other stakeholders will give you to the discipline. The number two is that we are all talking about the constitutional right of the access to justice. Just think of the economic profile of the litigants. How many years a litigant they can carry forward? There are cases that they have backed out from the process. And the older the cases are, the number of order for non-prosecution is being more. That is a failure of the constitutional machinery. And we are only responsible for that. Just you are using every moment of your judicial hour. But these, what Justice Sahu has stated just before that, it is all about how you manages your cases. We generally call the case management. I talked to some of the district judges. I talked to that, make it a habit. Everybody is now getting a desktop in his office, in his court. a dynamic Excel sheet of all your cases. I know that all the information is available in the CIS, National Judicial Data Grid. You can go through it. But as a matter of fact, I know if you ask yourself, the last 1 month, how many times you have just opened the CIS to see your court information or the National Judicial Data Grid? The answer will not be the encouraging, I'm sure about that. Because throughout the court hour, you are very busy, and up to the end of the court hour, you find you are totally exhausted. No energy is saved to go through the statistical exercise of the court. Make the process simpler. Engage one of your court clerk and make if you have the 600 cases, you have the 1400 cases, in one Excel sheet, let all the cases be there. And if you open, you can see what is happening in the cases. Then you can plan. And the third thing I will say, our cause list management. It has become the old practice. And most of the time, court clerk suggests that this time can be posted. You say, yes, post it. At the time of posting of a date, as a reference has been made to the section 309 of the CRPC, most of the time we forget what is the mandate in that section. And some real practical difficulties is also there. Because adjournment is not foreseen by a judge. And when under certain unavoidable circumstances we grant an adjournment, you find it difficulty to post the case following the principle that has been laid down in section 309 of the CRPC. Now we create all difficulties for ourselves. So there are certain areas. I think every district judge and the chief judicial magistrate is the captain of the group. And a good captain always take all its members together. And he is the bad captain who is only guided by his ego, his stubbornness, that I will not listen to anyone. Please listen to all the judicial officers, what is their difficulty. Take them all in. We call in the management studies, there is a catchword is called the change management. Change management is a daily practice. It doesn't, you can impose in a meeting, monthly meeting, you say, this month, do this thing. No. Change management is a daily practice and is a culture. If you take a decision, the first resistance comes from yourself because you have to change your approach. If you cannot change your approach, you cannot be the leader for the change management. Every captain has to put himself in the front line to show this is how the system can better work. That is my humble request. You have all the potential, you have the experience, you have the knowledge empowerment. Only thing, you have to sit back, how to change it. Don't look at the High Court. I believe when you take the responsibility, and that is what Article 235 is all about. It is all about your independence. The other decisions High Court takes is a matter of a guidelines. Some disturbing orders are passed by the High Courts. And some disturbing orders are also intervened by the Supreme Court. But these are the exception and aberration that should not affect you as the leader of your district. My plan was to talk to you, to get your experience so that our inspecting judges can share the experience and can involve the High Court to help your ideas in the district. I am told, and to be very honest, I say, I intend not to believe this, what I've been told by some of the retired judges of the High Court, that in a district judiciary, there is a fierce psychosis about the High Court. I quote, not a single word I have put. And then I thought, someone must be witch hunted. It happens. It happens somewhere in somewhere. I asked myself that definitely that has happened. There is a fear. Maybe High Court is not properly taken sensibly your difficulties. If that is so, I am telling you, time has come to tell yourself that if I work properly, High Court will not take any action. I think all the brother judges here and those who are on the line, they'll agree with me to create the fierce psychosis in the district judiciaries is the most retrograde step in High Court can take. They have to listen carefully. Some judicial officer may have really serious personal difficulty. We have to be responsive, we have to humanly responsive and try to solve the problem, not to create and aggravate the problem. You become open. I know that some of you are far away from your home, but it has to be done. We have to manage the districts. But when you are in the district, work hard. And High Court is there to look after your amenities. I believe High Court is discharging the duties, not equally what is to be done immediately. That cannot be done, for there are certain obstacles in the way. But ultimately, not as a Chief Justice of the High Court, as a citizen of India, I want to see the Orissa judiciary is the most vibrant, responsive to the need of the litigant people who come to have the speedy and affordable justice in the district judiciary. And 80% of the litigant are approaching you only for the dispensation of justice. We'll discuss in the second session more elaborately, where you will speak more, we'll speak less. Before I just conclude this, some inaugural comments, I want to say the last words, that you are not less independent as judge as the High Court judge. You are equally independent. But providing independence through Article 235 will be the dead letters unless you imbibe that spirit within yourself. This is the time, let us all rise to make the district judiciary really the bedrock of the Indian judicial system. I was reading an advertisement, and I will share it. This is very small. It actually is a Spanish saying. It says, sports is not just the game I play. Sports is who I am, what I am, why I am. It is every second on the clock, every moment I live, game day or any day. That should be our approach. I will make the change. Believe in yourself, and let us also believe in yourself. Thank you, everyone.
Thank you, my lord, for your gracious words of wisdom. With this, we have come to the end of the inaugural session of the Colloquium on Administration of Justice, the District Judiciary. We will now take a short break for tea. I request all the respected participants to gather at the Academy's portico for a group photo session with the honorable judges. And we will reassemble here sharp at 11:10. Thank you all. Thank you, my lords and my lady. I now humbly request my lord, Honorable the Chief Justice, to kindly take this session forward. My lord, please.
So I think everybody is comfortably seated and we start this session. In the inaugural session, I indicated this will be mostly based on conversation, not a format, and we'd like to hear you more. And when I request you to hear you more, I mean that you will be bold enough to tell the truth, even if the truth is not palatable to us. But the focus area would be how the High Court can help you in enhancing the functioning of the district judiciary. And what you think that we can innovate, we can take that creative approach for addressing the backlog, for enhancing the quality of the justice delivery, and further regarding the human resource management, which is a very ticklish issue for all the districts. And also sometimes that some complaints you get against the judicial officers as a district judge, or for a matter of record, I tell you, we get some complaints against you also sometimes. And how do you deal these complaints? Because one complaint is not attended to means a little corrosion about your authority and a serious corrosion about the institutional functioning. Because some person has a grievance, if you do not handle it properly, he will be grumbling all through the process. These are the areas mostly that I want you to tell us that this is the way the High Court it functions in a particular manner that will greatly help the judiciary, the district judiciary to enhance its performance in any other matter, including infrastructure, IT infrastructure, your other difficulties. You can tell all the areas, then don't take much time, only just the bullet point the problem, and so that other can also participate, we can also respond from our end. Recently, there is one issue that actually I can call it a cutting edge concern of the judiciary in the Orissa is that high rise of frivolous litigation in all the courts, all levels of courts, including the High Court. So this issue is very important if you finally take your strategy to reduce the pendency. Pendency means one frivolous litigation, if in the pendency you have to take almost the equal time for a very serious litigation. So therefore this statutory mechanism is there in place to scuttle this frivolous litigation. Sometimes we become very flexible, very mechanical, and guided by the practice. And sometimes also we think let it be hard, but ultimately this attitude leads us to this huge pendency of, and according to the estimate made by a Supreme Court judgment in 2021, I think all of you have gone through that judgment, that the 15% of our pendency are of the frivolous litigation. Those should not have been come in our system but those we have entertained. And 15% is a nowhere less number. We can ignore just. It's not that number. I will give you the two examples. First of all, that during the framing of the church, if you are also convinced there is no material ultimately left to any purpose for the prosecution, we are on the basis of the part of the police report, not that I'm not talking of the evidential materials. Evidential materials is scanned by you. We frame the church. What happens? Those who are financially empowered, they'll inevitably come to the High Court to challenge the framing of the church. And High Court may or may not, depending on the approach of the judge, will sustain your order or interfere your order. This is one area. I think it comes from an approach that I would only seriously read the prosecution materials filed in the form of the police report. When I will not frame the charge also, I will start recording the evidence. I have come across so many judges. I'm not talking about your state that way. I am not very acquainted with your functioning also. They're that closely. Then for the first time, they start reading the 161 statement when they're recording the evidence of the witness. They have not read the materials earlier. And that too, he doesn't know that what witness is going to say. This area, entire approach has to be changed. On this Khurda, this is a dialogue organized by Justice Sahu. I was telling them, I was in the California Federal Court, those who tries the hurt terrorist. I was there for a part of an Indian judges delegation. We very closely witness how they function, because to learn how in the other jurisdiction things take place, what they do. Justice Sahu has also indicated in his introduction speech. They organized, they call it as a conference, but in our CRPC, but in their practice direction that is there. The nicety of their rule-making exercise is that their Supreme Court, they do not have the High Court, do not frame the rules for the district courts. The district courts frame their rules. And the rule is published. District court has their own report that is published. And the decision of the district court creates the precedent, which is not available in our jurisprudence. Why? So that there should not be any difference in the same district regarding a particular decision or opinion. And the office of the public prosecutor is highly empowered by the state. It is not the police officer who takes the decision whether the charge sheet should be filed in a particular case or not. It is the public prosecutor who will take that decision. He will have a conference with the police officer, and thereafter, and the statistic is really, really striking. I was talking to this is a public prosecutor, very senior public prosecutor in California, Orange County. He was telling us that 60% of the charge sheet proposed are not accepted by us. Only 40% survives. But in our system, because of that quote-unquote fear psychosis, the police officers, because his performance is assessed, how many charge sheets he has filed, how many investigations he has completed, how many convictions he could realize through the investigation. These are the all performance indicators. But in USA, these are not the performance indicator. Performance indicators goes from the public prosecutor's office. And the public prosecutor has taken that one officer, in a year, he filed the 3 charge sheets. All the charge sheet was rejected by my office. But I wrote a highly appreciative letter to his authority that he is one of the brilliant investigators. Why? He did not leave any part of the investigation, whether it goes in favor of the accused or go against the accused. So when the materials are being examined at the level of the public prosecutor, all the three charge sheets were actually scuttled, was not accepted by the public office for framing of the charge. So what happened? That unnecessary litigation in that the gate is stopped. We don't have that system. Though initially the idea after the Malimath Commission report, you all know, the idea of the office of the director of the prosecution was on the same pattern, was thought of. But it did not happen that way. The director of prosecution only now supervises the performance of the public prosecutors. And those doesn't have any power like this to say this charge sheet will not be filed. He's supposed to be a postman to present the charge sheet, or in some courts, I find the police officers comes and file the charge sheet themselves in this inspector's office, and inspector office process that to the judicial section for taking cognizance. So this system is not ours, but the frivolous litigation, because of absence of some kind of filtration, are coming to the court directly. And here lies the importance of the court scrutiny. I would request you that at the time of taking cognizance, or at the time before framing the charge, either at the time of discussion of charge or pre-charge hearing, whatever you call it, you please very carefully go through the record. Made it a practice. I am telling you, the trial is understood by you 60% if you go through the records properly at that stage. Everything comes under your grip. Then you know whether the charge would be framed, if framed under what section. You know for the charge you are framing, which are the material witnesses or the objects that you will rely on. Otherwise, you will be beating the bush. When you are framing the charge, lawyers will make the lengthy arguments at the framing of the charge. And you have to give your important times for hearing those pre-hearing, this time for framing of the charge. And you just take note in your own way, by using quotes. This is the important witness whose role will be important for the delivering the judgment finally. Then you have a conference informally. As Justice Sahu says, ask the public prosecutor first that who are your important witnesses. Have a discussion in presence of the defense counsel. He will give a list. Initially, he will come unprepared. You know what the experience with the public prosecutor. All of you know that. Hardly there are few public prosecutors, they are very serious in their job. So let them also be on task. So you find a list. This is the priority witnesses. First 2 dates, you fix date for those priority witnesses because you know entire fate of the case is dependent on them. And strictly follow the mandate of section 309. Day-to-day recording of the witness, because you have now selected a small group of the witnesses, which is very material for the trial. And don't make the compromise. And regarding there is another issue regarding issuance of the summons. You please have a meeting with the superintendent of police. We held a meeting. They all always say that we'll cooperate no matter if you find any difficulty, call us. So through them ensure the summons are properly served. Now the second phase comes, that when you start recording evidence, what we are finding, because I'm quite for some time, I'm hearing the criminal appeals from the various districts. Lawyers may be inequipped because we cannot play a very important role in equipping the lawyers. Though we have started as lawyer capacity building program by providing the database, e-library to this bar association. You know what? That even if you have the books in your chamber or office, I'm talking about a lawyer, hardly they open the book. They always learn from the convention. What is the convention? Convention, how the senior dealt with that issue. And most of these kind of lawyers do not get updated what has happened in the recent development of law. It creates a lot of difficulty because he will try to argue before certain things. You know, this is no more arguable. This is already settled by the certain decisions of the court. So you have to tell them that this has been decided. I'm coming our part. Now, just one common error I find, regarding recording of the contradiction or omission. You are the senior judges, whether you are a chief judicial magistrate or the session judge or the holding the dual responsibilities also with some other special courts also it may so happen. This last 3 occasions, I got 3 cases. And one was Justice Shashikant Mishra, brother, that we are last few days he heard. I was asking the lawyer, he was banking on, sir, this is the contradiction. I'm giving one example without referring to a particular case. What is there? Did not ask any questions to the witness who made the statement. He simply asked, did you state to the police officer this? He may answer yes or no. Recording is stopped there. Thereafter, straight away, they swing to when the investigating officer coming to testify before the court. Did this witness told this to you? He answers yes or no. Do you get my point? How it is material? If the investigating officer says, yes, he told me, that doesn't form the evidence. Law is well settled since 1959 from the Tahsildar Singh's case. How to be contradiction has to be recorded. And I tell you very frankly, the interplay between section 162 of the CRPC and section 145 of the Evidence Act, lawyers grapple under the various circumstances how to apply these provisions of law. Suppose something completely a new fact is introduced in the trial by a particular witness. We all know this will come under the category of omission. How the omission should be recorded? First, you in the examination in chief, whatever the witness says, you recorded it. And after that comes the duty of the defense counsel. That whether you stated this to the police officer, he would say, yes, no, there is no issue. Because it is already proved that he did not state, so whatever way the court can decide. If say yes, now both the duty of the defense counsel and the trial just comes into. If the defense counsel fails to block, no, you did not tell. If you told, just show me from your statement. You will not be able to find out. So what the court will do? Court will mark that part of the statement within court that it was not found in the 161 statement. That much is the role of the court at this stage. And thereafter, of course, for confirmation by the IO, that particular fact with reference to what have been quoted in the deposition, and the IO says no, then it becomes a contradiction. You have to reject it. Under law, you have to reject it. The omission immediately turns to be a contradiction. You cannot depend on this statement. So where is how the court plays this rule? You may ask me, court has been given the much greater responsibility not to sit as the umpire between the two counsel. The trial judge has to be proactive judge. Because you have twin duties. Number one, to find out the truth through the trial. And number 3, to ensure that the justice is not frustrated. So Section 165 of the Evidence Act, given power in the hand of the court, that is what we ask the intervene. Someone is something doing or the playing with the trial, you intervene and debunk his approach in the trial and by way of recording. How many of you have recorded this demeanor of the witness in the trial? It's a rare occasion, because you know that only when you will be the record the demeanor, only it is so stuck in your eyes that the witness's words are less important than his or her demeanor. But please record the demeanor, because when the matter goes to the trial, you are seeing the witnesses. And after recording the statements, you come to know which witnesses are stating the truth or not. There is a general impression is created. Because our human faculty is very sharp. Someone on the face of you tells the truth. You may not prove it that he is telling the truth, but you immediately get a gut feeling that that gentleman is not telling the truth. And this kind of a suspicion throughout the trial is to be obviated. Otherwise, at any point of time, the testimonies become subject to the doubt. Again, there is an issue. I have come across at least 5 judgments that after discussion, you have clearly rated that prosecution has failed to establish the case without reasonable doubt. You owe a duty. Why are you branding that group of witness or a part of the evidence or the entire evidence that is visited by doubt? You are to embark on the reasons on that part. Simply do not draw the inference in the fagin that is visited by doubt. How you have formed the opinion of the doubt. You give one paragraph at least that this statement is created. It is unbelievable for 1, 2, and 3 reasons. We always follow in Indian jurisprudence this Lord Denning's, this great case Miller versus Miller. What is the doubt? Doubt is not in your eye. Always remember that. Doubt in the eye of an ordinary, prudent person. The 2 words are very important, ordinary and prudent person. So the person will be ordinary. He is not highly intellectual. He doesn't have the forensic knowledge to make a distinction between reasonable doubt or doubt, or the deviations, minor insignificant deviations, the distinction the ordinary people cannot make. What ordinary people that this cannot happen. What he's saying, I don't believe. This is the ordinary person's reactions. So the ordinary person's reaction should be followed by a prudent person's test, whether this sense should be accepted by me or not. Ordinary persons, you are the same persons, is a split personality. Mr. Hyde and Mr. Jekyll in yourself become the ordinary persons and the prudent person. The ordinary persons, the inference that you draw, the prudent persons will come and test it, whether it can be treated as a piece of doubt or not. This exercise must be there if you want to improve the judgments. Thereafter, the several issues are there. I'm just giving the illustrations for your understanding that what we are finding difficulty. In the trial, you all know the law by now is a highly consolidated regarding recording the examination and recording the statement of the accused person. First of all, by way of the amendment, now even the public prosecutor can place, earlier that was not the law, but that was the practice. They can also put certain questions to be put to the accused person during examination. But these are mere suggestions. You have no obligations to follow those questions. Why? That is the final stage of the trial. You are giving the accused person the natural opportunity of these principles of natural justice. And that you will answer. There can be the two things. If you are not properly scanned the evidence. I mean, after the evidence has been recorded, now the 161 statements is completely discarded from the record. You'll go to the testimonies. I am telling you, as you are very sincere and honest, I am telling you, when you go through the evidence, you know what I will rely for writing my judgment. This is a process of discarding things. And take it from me, this is really a process of discarding evidence. After that, you do not discard the evidence. After that, what you do, you appreciate the evidence, which according to you, admissible and acceptable. So when you are reading yourself, before the section 313 of the CFPC, you are discarding the evidence as a judge. And the evidence that you are going to accept, you now work on them because you know by development law, it has become mandatory unless the evidence that you are going to rely, you do not put the question because of it incriminating the accused person. You cannot in the judgment rely on those part of the evidence. Just think of the seriousness of this exercise. Perhaps we do not approach this process with that seriousness. It is required that we must do that if you improve the quality of the judgment, improve to shorten your time. The moment you are posing the questions to the accused person, you have zoomed in the entire evidence to the certain questions. And beyond that, you know you will not travel. So your work almost done now. You are only to dictate the judgment. Because it says, I think all of you know that this is a famous case. This one of the famous case was actually decided on the response given by the accused person in the 313, which is that case. And that was the last case for a particular mode of trial. Nanavati's case, right? The jury trial, that was the last jury trial in our country. So it is a very important phase of the trial. And sometimes we do not actually give that kind of the seriousness to this exercise. And thereafter you write the judgment. And you decide. We have no issue on that. I find the standard of writing judgment skill is very good in this stage, on an average. They have a structure, they have a reasoning, they have given the inference drawn very clearly. And some of the judgment, I must confess to you, I find really it was amazing to read. Such an effort has been put. And I believe most of you are writing good judgment. I have not come across all of your judgments. And I find myself a little gratified that such judges are working in the Orissa Judiciary. And in my mind, I have a lot of appreciation for you. This is not happening throughout the country. Please do the good work on. And there is no end to the good work. That I read out that advertisement. It says every moment is important for a sportsman. Only yesterday's newspaper, the famous Olympian, the swimmer, Phelps' interview came up. He just told in the interview that some of the fellow swimmers from the other country says that why you also exercise on Sunday means you exercise all 7 days. He smiled and replied, this is why I am Phelps. A judge's life is 24/7. You cannot stop your thinking process the moment you go home. And that creates a lot of difficulty. This is the area of stress that is very important. How you relax yourself. Unless you get your brain rejuvenated every time and every day, you cannot get that amount of energy which is required for this kind of serious intellectual exercise. There are issues as very negative factors. We also, when I'm taking about the serious intellectual exercise and say a stressed mind cannot do that serious intellectual exercise, you should revert a question back to me that you are giving us the target. You are giving us within 1 month, you have to do this. How to do that? That is where your challenge lies. We have every right to set a target for you. But your capacity, your strategy, so the case management strategy is concerned, will be tested how you address that issue. For failing to beat the target, nobody has been punished ever. But about you, an assessment may come down to a particular judge who is following you. In this regard, that we want to help you. I asked the Registered Judiciary to open a committed desk in the High Court to analyze all the information. So at time we can also supply you the feedback. The things are maybe required from your end, certain modification, certain, again, the review exercise, why this is happening. It is a collaborative and joint process because we are holding a collective conscience for the justice. I was just referring to this regarding the frivolous litigation. So at the time of when you are claiming the charge, be very careful. Don't persecute a person who should not be tried. You know, going through the trial itself is a punishment. Though we say it's not a punishment. He suffers social stigma and everything. And it is a high responsibility with all the trial judges. Please, please, and please carefully scan the evidential materials which are the part of the police report. And try to imbibe this kind of a culture in your district judiciary. When you talk to each other, talk about these things, not with a particular specific case. If you can stop the frivolous litigation. Another area of frivolous litigation is the complaint case. A complaint is, police did not take, a complaint is filed. I was checking 2 complaint cases. That was not before me. I asked from the registry to just examine how the things are done here. Suppose some person has filed straight away a complaint to you. Would you accept that complaint? Forget about what has been written, whether the cognizable offense has been made out or not. Forget about this thing. First, at the threshold, whether we will accept the complaint or not. Answer must be no, because 2 Supreme Court judgment has dealt categorically with that aspect. That there is in section 154, there is a let down provision. If police station doesn't accept in first information report, apart from the 2014 Supreme Court decision, is a duty to write to the superintendent of police of that district that this has happened. And if thereafter also his case is not registered, of course the citizen has the right to approach the court. Also some other occasions. But he has to make a categorical statement in the complaint that I have done this. If in the complaint that is not there, don't entertain the complaint, because in 99% cases, these are all frivolous litigations. Like ordinary citizen, we cannot just say the police are doing all the district service. We know, because that is why it's a 99%. In some cases, police shown interest on different considerations. This is a separate issue, but for that the complaint should be drafted differently. So if you can stand, you are serving the future of this institution. Because you are taking out some frivolous litigation from this system. Another aspect regarding the civil cases. I think most of you have served more than 10, 12 years as the district judge. And some has already served few more years because otherwise you are not made district judges. When we are in the law school, we were given a problems regarding when the preliminary issues in a suit is framed. We brilliantly answered at that point of time. So these are the three conditions. If found, it is immediately struck down. No further trial will continue. How many of them you have exercised that provision when the suit is filed? You may answer, and that will be also a very correct answer, that unless a special application or in the written statement, the objection is taken by the defendant, we do not have any responsibility to frame the preliminary issue. Am I correct when I'm saying this? Absolutely, I'm wrong. Framing of the issue, either it is a preliminary issue or the general issues are the entire responsibility of the court. Right? They only suggest, but issue is framed by you. You take help of the lawyer in the form of discussion, but issue is exclusively framed by you. So, similarly, when you are going to the stage of issue, you again check, because the order 7 stage is over. Your office has not touched has not returned the plane for the objection that can be taken under order 7. Now it is come to the level of the issues. You just go through whether at that time any point was missed. Frame the preliminary issue so that the life of the suit can be shortened. There are 2-3 judgments are there that you can also pass the order partly allowing the suit without entering into the trial. But there is certain difficulties also. Difficulty and to be yourself to be there, you cannot pass a decree on the basis of this observation, but the suit is partly decreed by you. You can pass such order. Why? And you should adopt that practice. You should pass these are issues and admitted by the defendants. Means you are taking all these issues out of the general, this set of issue that we are framing. So you are concentrating the remaining issues. And thereafter, you adjudicate those issues and that part of the order march with your decree. Make the trial shorter, emphatic, and time will be required less. I was doing an exercise at one point of time for these district judges for the National Judicial Academy. I found out if you even give the adjournment for a shorter period like 15 to 20 days, trial of a suit can be completed within 149 days. Almost half of the year. Then the question would come why you are failing into that. Because we are failing in our role. We are very casual in plan out the trial of the suit. And despite the laws that are coming up, because of this, that is why I am telling it is high time to show you are different, you are changed, and that will inspire a lot of judges to follow you. And I'm telling you, you'll be reducing your stress because you know your case. Most of the stress comes in a hurry. You are fixing 7, 8, 9 matters together. You are not properly studied those files. You are completely bewildered. You do not know what to do. That is why I told that you keep the dockets ready and you know every docket. take time for 1 month and study every docket, then you find the stress has been substantially reduced. A person who do not know what to do is more stressed. So that there is a case management strategy in all procedural law. But what is required? Your innovative approach and creative approach to this procedural law. All the practice directions come from the High Court or the Supreme Court. How we can do that? I give you one example. That perhaps give an example from the civil suit. You are keeping 2 dates, one for the discussion of the issues, another, you will keep another date for framing of the issues. Can it be done within 1 day? Is there any legal bar? There is no legal bar. And you know when you have studied the plaint and the written statement, that what are the issues? There is no question of even certain cases to give the date for the discussion for framing the issues. So you frame the issues. And the day you frame the issues, you asked on the next date that the plaintiff or the defendants to give their witness list. And I fix a date accordingly that you shorten, because if you list by the plaintiff 1 date, it is not criminal trial. The defense will decide on the basis of hearing the evidence of the prosecution, whether they would give the evidence or not. It is a civil suit. It does know from the day one that what I have to prove. Because if the written statement, they have placed his own defense, not only the denial, but a separate case has been put. Defendant does know that he has to put the evidence in support of that evidence. Inevitable, otherwise, if he doesn't give the evidence, he'll suffer the consequence. So you does know, give the date, and thereafter you go for the evidence. I am filing you that I found 149 days is required to complete a suit, whatever complex suit is there. But we are compromising somewhere in between, in the midway. We are giving even dates. We do not finding the time for the judgment writings, because in the process, we were not mindful. In every stage, whether it is a criminal trial or a civil trial, you are dispensing with this justice. You are deciding every stage of the trial. Every decision ultimately influences your final inference in either it is a civil suit or it's a criminal trial. So another important aspect, and that I'm finding, granting the bail. Maybe that you may say that will be criticized by the High Court, we are liberally granting the bail. Now, from 21 to 23, the Supreme Court has spent a lot of time on dealing with the issues of the grant of bail, both under Section 439 and 438. Here is a problem that we do not consider at the time of considering the bail applications. The basic foundational things of Article 21, whether the sufficient materials against the accused person is there to curtail his liberty, even temporarily. Non-grant of bail curtails the liberty of that person's temporarily. And the gravity of offense, nature of offense, this is the other aspect. I would request you, because I find the Member Secretary Legal Services Authority is there. In the recent judgment of the Supreme Court, this Asfaq Khan has given the 498 matter how to deal with that. And if the Section 41's requirement is not complied by the police, what the judges will do? Everything has been made very clear now. So what is the other important aspect is that how to deal with these matters. First of all, in Orissa, I find a lot of under trial prisoners are there in the jails. Very less is the convicted persons. So the Supreme Court has, in a series of decisions, has told the district judiciaries in particular, that when a U2P punishment is maximum 5 years, if he is in custody for 1.5 years, that is the exact stipulation. And 7 years, it is around 2 to 3 years is served. Grant all of them bail. There is some difficult areas that even if you grant the bail, they cannot find out their surety. You wait for some time, and through the Legal Services Authority, you direct them who are those persons are failing to give the surety. Please relax the condition. Give the personal bond with stricter conditions to report to the police station and give a directive to the police officer. Release them from the bail. I remember on the Constitution Day, the President of India, Draupadi Murmu, as you know, he comes from the village life. He does know much more than any of us about the village life. She was accusing the Chief Justice of India. Our children fought between themselves, either having a drink or otherwise in a mela and other thing. Now they are in jail. Your entire family, entire village is suffering from them. Chief Justice, you do something for them. And I will also ask myself also do something for them. And I'm just relaying my concern to you because I think it is one of the cutting edge concern. Please do something for them. And I would request the Member Secretary, Legal Services Authority to take a huge move and to go to every jail to find out the UTPs and see their tenure of this incarceration temporarily by year of judicial custody and file the applications to our panel, this empaneled advocate, to the courts, and court take a very liberal approach in granting them bail. And also, when you know that the common balance in granting bail is that you look into the interest of the prosecution and look into the gravity of the offense. And you also, when discussing these two elements, think if the bail is granted, well, the bail will be abused or not. For the person who has committed the first time offense, you do not have any idea what way you would conduct. So the benefit should be given to the accused person. As Justice Krishna Iyer says, and is famously quoted everywhere, but now it is less quoted, that the bail is the rule, the detention is the exception, because of the Article 21. So grant the bail in appropriate cases. You are the judge, you are the independent mind. Nobody is controlling your mind. Grant the bail. As you do when you pass the judgment, do you think what will happen to the superior court? I don't believe you do. And those who think that I may be criticized for giving this decision, you are no more independent. Your intellectual integrity immediately questioned. Do what you think best to do. Your only anxiety as a judge would be there to do the right thing. I stop here. I would like to hear you, and also my brother judges and sister judge will open up a conversation with you. Please come up. We should not be the slave of our old habit and old convention. It's a new time. We have provided the technology, and we are also that some judges I know under your jurisdiction have a difficulty regarding having the stenographers. We have already doing an exercise to provide them the speech recognition software, like just Dragon software, which you dictate and type and accurately almost 95%. And anytime you can, if you on the home also, if you record the judgment and you put it in your computer later on, it will automatically type out. So, and this will be huge training will be given. I think at least it will lessen some burden for what situation that has emerged for non-availability of these stenographers. And this is a collaborative process again. We are trying to help you out. Please show the results in the ground reality. Orissa Judiciary has a great prospects, and you are the proponents. I think you understand this, the role changer role in the change management of the judiciary. And therefore, what I want to say there as a last word, don't be a mute spectator of what is happening in the judiciary. Be a proactive judge, yourself change it, and your change should be imbibed into your fellow colleagues who are working with you in the same district. Thank you, everyone. I think Justice, Justice Sahu may take over if you want to contribute. No, just you just coordinate the thing. So,
Honorable Chief Justice, my esteemed sister and brother judges, and district judges, Chief Judicial Magistrate, and other judicial officers present. Honorable Chief Justice has wonderfully dealt with the problems which all of you are facing as the officers of the court, maybe in criminal side or in civil side. And very good suggestions have been given. And if it is implemented, if you are not implementing already, I hope that most of the problems should be sorted out. But one thing, sitting here, when your Chief Justice is telling that remove the fear psychosis, work according to your conscience, do the best what you can do, maintain integrity, honesty, then I hope that is the best thing you are getting. The indication from the High Court that you are not to fear while discharging your duty. So, when you open up any weekly cause list, now it is available to you, you'll find that 3 courts almost deal with anticipatory bail application. 1 court or 2 courts with regular bail application. 1 court with 482, this cognizance coercing matters and bail jump matters. And 1 court may be dealing with the revision cases which deals with the passing of the charges framed or rejection of the discharge petition. So the number is huge, but question is that whether those clients were justified in coming to this court or the problems would have been sorted out at your level. That was the thing which my Chief Justice was hinting at you, that at the stage of framing of charge, if a discharge petition is filed, please apply the mind and don't rely on few cases that at that stage we are not to go deeply into the matter and just mechanically cyclo-style order reject the discharge petition and leave it to the High Court. If the party has financial capacity, will go to the High Court and challenge the rejection of the discharge petition. So the hint that is given to you that when the section itself says that if there are sufficient ground of proceeding, then you are to frame the charges. Then what are those materials which are available on your record so that you think that there are the grounds? Otherwise, it would not only one case just added to your board, but it would cause huge pressure on that particular individual. He may lose years of sleep while prosecuting or while just defending his case. So I was checking of, I was just discussing, I'm telling you that I got the data from the Khurda Justice that how many anticipatory bail applications have come from that particular district from January 2022 to end of August 2023. The number was huge. And when I collected the data from the district court of Bhubaneswar and ADJ court of Khurda, how many cases have been filed anticipatory bail application? The number is just 150 in total, but it has gone to 3,000 odd in the High Court from during that period. And I told that most of the cases are 506 matters, 498A matters, all like this. So why I asked myself that why in such type of cases, without approaching the district judges for anticipatory bail, why they are rushing to the High Court? What is the problem? Are they under a fear psychosis? That if we grant anticipatory bail, somebody would question us, or the clients have that feeling that it would be useless for us to approach the district judiciary because our bail application will be rejected. So if either of these two things remains, then it is certainly a thing which is to be taken care of. The people must have confidence at least in these matters. We can approach the district judiciary, we can get the relief, and it is you, the district judges, who can create that confidence. You can have the dialogue with the bar members. You know that. And what is happening here, that the valuable time of those honorable three judges they could have devoted in other wars, that is spoiled dealing with this application. I'm not telling that all the applications are coming and the higher offenses that will not come. That's there. But this is the one of the examples which I give to you. Another thing from the experience from the trial side, I find that while you are adorning the chair, while you are conducting the trial, unless you actively participate in it, most of the unnecessary things will come to your record. And there can be said that some kind of dishonesty would be practiced by either of the side of the counsel. How I say one example I'm giving. Suppose an eyewitness supports the prosecution case. And after chief examination, the public prosecutor leaves and go to another court for some work. And at that point of time, confrontation is made to the previous statement that you have not stated before the IO like this. Entire thing has been confronted. Judicial officer is sitting idle, or he is asking the some officer this about the other wars. He is not checking the 161 statement whether it is available or not. This confrontation, he is telling that you have not stated whether it's a fact or not. He is not checking. He is engrossed in other wars. But what he is confronting is the second statement, which has been recorded by the police, that is on some different point, maybe on the seizure on some other aspect. In the first 161 statement, that witness has categorically stated about the occurrence part. In the second part, that is taken after few days, it is on different part. So he is referring to that and not giving the date of that recording, but he is asking, and the witness says, no, I have stated like that. Now again, that is recorded, and when the next stage come, that counsel will just ask the IO, please look at this statement. That means the second statement. Please see that whether he has stated you before this. He will say, no, he has not stated. So unless the public prosecutor is very active, is very thorough, unless the court is very thorough, this would come on record. And what will happen that the entire statement which he has given in the chief examination will be nullified on the ground that he has not made any such statement before police. But that is not a fact, that was there already in the past statement. So actively participation, what my Honorable Chief Justice is referring to, that not only that, but you can also, once you know it, what is the unnecessary questioning, frivolous litigation, that you can, at your level, you can check. I'm giving an example to you. When I think of that incident, I feel very shocked. I had gone to conduct a case in Champua in the ADJ court. So the public prosecutor was training a witness. That witness is the widow of the deceased. And he's telling that you have seen the seizure of this weapon and you have put your signature. That witness was telling the Babu, मैं तो, मतलब I am telling in Hindi because everybody would feel comfortable. बाबू मैंने वो देखा है, मेरे हस्बैंड को कैसे मार दिया, वो मैंने देखा है. वो पब्लिक प्रोसिक्यूटर उसको बता रहे कि बकवास मत करो, ये कुछ नहीं है इसमें. अब आपने ये जो देख रहा है ना, ये आप ही की तो है ना, जो तो इसको सिर्फ आपको कहना है, वो बाकी जो देखा है इसके बारे में कुछ नहीं है, तो इसको कहने की कोई जरूरत नहीं. So that witness was crying like anything, that I have seen my husband was murdered in my front, and he said that nothing is available on record. Public prosecutor is telling me like that. Then the witness comes to the door, takes oath, and as per the whatever he has trained, he just guided that witness, and the witness only tells, with all crying, approve that seizure list and goes out. Then the lunch period comes. So I was sitting when this thing was going on. So out of curiosity, I just checked off that police paper which was supplied to that public prosecutor, and I find that in fact there is 161 statement recorded of that witness, and she has stated categorically about the occurrence part. See what has happened. An eyewitness to the occurrence, who is the widow of the deceased, has been made a seizure witness by this unfair practice of the public prosecutor. And at that point of time, I'm asking myself whether the court is a silent spectator, whether if the court would have checked the case diary, whether he would have made thorough research, whether it would not have found it. So it is not your duty just to listen the questions and take down what is there. You are not a recording machine there. Your duty is something else. I would listen from all of you during this discussion. Whatever innovative ideas you have already implemented, what problems you are facing, and we hope that if one problem is faced in one district, if it tells the other judicial officer, he might have faced that problem and might have already sorted out, and he can give also the idea. So in this way, this interaction, the purpose of this organize this colloquium would be successful. So
since now we have already discussed our problems, and Honorable the Chief Justice and Honorable Justice Sri Shahu has deliberated on this issue, all these issues, and have given their anxious thoughts and also advices also. So now I request the esteemed district judges and judicial officers to interact with us. Now it is your turn. Please begin.
Sir, Pranam. I am Vishwajit Mohanty, District Judge Kendrapada. I am District Judge Kendrapada, Vishwajit Mohanty. Sir, at the beginning, I humbly expressed my deep sense of gratitude to the Honorable Judges, Honorable Chief Justice for organizing this wonderful colloquium on an important topic like administration of justice. During the inaugural session, where talked about the managerial skill, how to dispose of the cases quickly. But the colloquium is on administration of justice. Administration of justice means administration of civil justice and administration of criminal justice. And today's colloquium is focused on administration of criminal justice. We are supplied with 17 judgments of the Honorable Supreme Court to go 19 judgments to go through before attending this colloquium. Some of are wonderful judgments, and we are also following the same in true letter and spirit. I am highlighting, I will be highlighting on 2 to 3 issues. And when we are talking of administration of criminal justice, we mean fair trial, ensuring fair trial, following principle of natural justice, granting bail, granting anticipatory bail, and not granting bail in heinous crimes, etc. These are some of the facets of administration of criminal justice. Now, the very important facet is Section 41A of the CRPC. And the Honorable Court has time and again instructed all the districts across the country to follow 41A CRPC. My, as a district judge for the last 1 year at Kendrapada, I have noticed that this 41A CRPC provision has been blatantly violated by the investigating officer. For example, hardly we receive any FIR under Section 323, 324, 325 IPC. Whenever an FIR is filed before the police station, in case of simple assault, the police immediately registering a case under Section 307 IPC. Because of just to get out of that 41A limitation and constraints. So when the accused is forwarded, it is a simple case of assault that is punishable under Section 323 IPC. And when an accused is forwarded to the SDGM is just, he or she is scared of granting bail. When the accused is forwarded on Section 307 IPC, that is the ground reality. He is not granting bail or she is not granting bail. And the matter comes up in an application under Section 439 CRPC before the sessions judge. As a sessions judge, I used to go through the FIR and this 161 statement, injury report, and etc. And I invariably find that there is no iota of evidence on the Section 307. I used to grant bail. But here is a case when the Honorable Supreme Court has highlighted and instructed the judicial officer across the country to follow the 41A CRPC, the provisions of 41 CRPC. Why the police? And I have also had an interaction with the SP in this regard, and the SP says that I am helpless. Why? He hinted on 2 points. He said, if I do not arrest the accused, the victim will be facing the wrath from the victim. If we arrest the accused, the 41A will be staring at us. So you are clueless. So that is the reason why we are invariably adding 307 IPC in a simple case of assault. So what should be my humble request before your lordship is, what should be the approach of SDJ while dealing with a case like this? Because ordinarily, the SDGM doesn't grant bail in a case which is registered under section 307 IPC, and the accused is forwarded under that provision under section 307 IPC. I was also coming across a case, just an excise act, cases punishable under section 52A. It is stated in the forwarding report that we served the notice under section 41A, but the accused refused. I was completely taken aback. If the police officer conducts raid, arrests the accused, and takes the accused into his custody, how can he refuse to receive the notice? So the SDGM refused the bail, but ultimately under section 439, he was granted bail. So my humble request before your lordship is how to get over those gray area where all these things are happening. Yes, ma'am.
Mr. Mahanti, if in your district, even though you have told the SP that the cases which should have been registered under 324 or 325, deliberately it has been registered under section 307 IPC for some reason, as you just explained. So they are doing their duty, it's not following it. But the magistrates, your magistrate, SDGM, or the other cog-taking magistrate before whom those cases must be coming, they are not helpless. They are not to reject the bail application merely because the case is registered under section 307 IPC. What section 437 says? That the magistrate shall not, that such persons shall not be released on bail if there are reasonable grounds for believing that he has been guilty of the offense punishable with death or imprisonment for life. So if there is no material before him, the injuries are simple. It is aggravated manner, it is, so he can write that bail application filed, I go through the materials. There is no material before me for believing that he has committed an offense under section where for imprisonment for life or death. Though the case is registered under section 307 IPC, it is not prima facie 307 materials are not there. So in that way, the magistrate can grant bail. There is no problem in that. Why there is merely because it is registered. What I want to say that he is not powerless to grant bail. And even 302 cases also exceptions are there that to what categories of person you can grant bail. So it's not absolutely bar for that. And at this juncture, I just want to add that when we are coming across such cases, I'm sorry to say in High Court in regular bail application, that 307 cases are rejected because the time limit has been fixed in one of the judgments of Justice Goyal that when it is filed within 1 week, you are to dispose it of. So 307 case, injury report has not come. Allegation is that it is a sword blow on the neck, so rejected, right? When it comes to the High Court and after 2 months, we deal with that file, injury report comes, it's a bruise. So the entire allegation that has been leveled that sword blows was given on the neck, had it been a little patience at that stage, right? And the injury report, the district judge or the ADJ who was dealing with the matter would have perused, would not have rejected the bail application. The person's 2 months custody is now, this is meaningless. So that is why we are telling that one judicial officer should know that how to tackle all these problems. He has to think over it. He has to take the assistance of the seniors. He should not hesitate. And how can that be maintained? You are a district judge. You have to keep coordination with all the judicial officers. You should be very friendly, not only with the judicial officers, but also the bar members so that it can run smoothly, your judiciary can run smoothly. If you just keep in contact with few judicial officers and ignore, they would have a feeling. They would not feel that we are in a family. So that is the requirement, that if you want to proceed all of them like family members. So once you give that feeling that we are here in the district court, I am here, I am the district judge, tell your problem. So they will tell you, and you will guide them. From your experience, you can guide them. That don't reject the bail application merely because the case is under 307. So that sort of approach, or that sort of spirit is required from the district judge to the other judicial officer.
My lord, my point, I am extremely obliged by your lordship's suggestions. But fact of the matter is that I have discussed the matter with SDGM, but in spite of that, the ground reality is she is scared of granting bail. That is my problem. So I
Honorable
pray-
Chief Justice has given a mantra to you, all of you, not only the persons who are present here, but all to the judicial officers, that remove that fear psychosis.
Yes, ma'am.
Don't fear. If you are honest, if you are not acting against your conscience, if your integrity is not doubtful, don't fear anybody. At best, your order can be set aside by the High Court, but nobody would raise a finger at you. Okay? So maintain that. The already signal has been given that go ahead. All right?
oblige, my lord. Oblige.
Just to add to what my lord has just said,
Mr. Mohanty, that one thing, I think there is the police officer invading the Article 21 in a very brazen manner.
Yes.
That converting without any the section from the 322 to 407 in the investigation level, it is apparently what you say is an unfair investigation.
Yes, my lord.
And the accused right is covered by this this covenant on the political and civil rights, 1962, that the unfair investigation actually violates the constitutional right of liberty.
Yes.
So you call at the SP level, just take out certain few examples that this is happening. We are friendly just drawing your attention now, otherwise we will be judicially moving. You can make a criminal reference to the High Court
Yes, my lord.
for taking the appropriate action.
Yes.
So you should know your weaponry also in tackling all these situations.
just to
Oblige.
add to what my lord has said, if the magistrate grants bail in that case, and if his order speaks for itself, if he has cited adequate reasons, why should he fear? He has to cite adequate reasons why I am granting bail, even if it's a 307.
Yes, ma'am.
He should justify. That's all.
And there is a general provision in particular case you have referred. If the investigation cannot be completed within 24 hours, investigating officer is burdened on another duty. He should file some memo of evidence he has recorded before the court to justify the registration of the case under a non-bailable offense. That also we must insist. Sometimes the police officer with a report, police report they file without these memos of the evidence he has already recorded. That we must also insist to the police officer, because it will be filed to you. You will see it.
Yes.
Otherwise, you on the next date under this exercising the jurisdiction is provided to you under section 172 subsection 2 of the CFPC, call the case diary. It is our duty in that stage of investigation to protect the right to fair investigation of the accused person also. That is why this provision has been made in the statute book. Section 172 subsection 2. Please look into that section.
Yes,
also.
my lord.
Another practical difficulty which we are facing, since you mentioned 41A, there's a provision in 41A, if that the accused does not comply with the notice and cooperate with the investigation investigating officer can arrest after taking orders from the court. But sometimes when the materials come before us, there is only a mention saying that notice had been issued under 41A. But thereafter what happens, that is not there. So if that would be there, it would be easier for us to deal with the matter. That is one point. And what Brother Mishra said, that if a few reasons are given for dealing with these cases like 307, that would there's no need to fear anything, because reasons, we also give reasons for that. The same reasons can be given by the magistrate instead of mechanically rejecting the order, and which leads to delay in dealing with the application also.
Thank you.
Another thing. Yes, Mr. Jenna, my district judge from Bolangir. When you get the chance, you discuss that problem which you had discussed with me, because that is a unique problem, and how to deal with that. If you share your experience without mentioning names, you just mention that you have to deal with, but don't mention names. Okay.
Yes, there is a problem that my lord was pointing out, that most of the officers are thinking that the bail application will be disposed of within a stipulated period. But what is happening, the investigating officer, they are neither producing CD, even though the CD is produced, the injury reports are not produced in most of the cases, in say to say 70 to 80% cases. And I was discussing with the magistrate, but they're saying that when the injury report is not available, then how can we prima facie hold that 307 is not met? Well, in most of the cases, they're also citing another reason, that ओडिया कहते पूरा बेकू को लक्ष्य कर मारला कि मुंडो को लक्ष्य कर मारला, एटा निश्चित थिबो, because in absence of that injury report, they're saying it is difficult on our part to prima facie hold that no case is made out. That is the main problem.
But are we really at the beck and call of the investigating agency? Are we so powerless? That is what exactly is to be discussed during the senior officers meeting. You have attended many times, Mr. Jana, with me, those meetings. We used to discuss, we used to ask the collector and the SP that why will the injury report not be produced at the first instance? You have to pull up the officers. We are not their agents. And you cannot curb the liberty of a person indefinitely only because the investigating officer says that I'm busy in investigating other matters. I cannot produce the injury report. Or if the doctor says that, sir, I have not written it. No, sir. We are talking of violation of Article 21. Yes. Sir, as my Lord has said, we must know our weaponry, what we have in our armory. A lot of weapons we have.
You should know how to deal with such situation. You should know what are your weaponry are. Unless you are conversant with law, this sort of situation will threaten you, and you will be under pure psychosis to deal with the matters. That's what my Lord Chief Justice has told you.
And another difficulty, my lords, in justice of a peculiar problem that I was discussing regarding disposal of 10 years and 20 years cases. And most of the officers are saying that Bolangir district is that migrant laborer problems. Most of the accused and that their witnesses, they used to travel other states for that work. And they are saying, and most of them returning during this Nuake. That is a major problem in the district of Bolangir in disposing Euro.
That is a very difficult area.
No, my lord, that is a problem in some districts.
some
Like
districts,
in Ganjam, 10 lakh people are in Surat. Some people come here to commit crime and then they go. So those NBWs will remain unexecuted for a long time. It's difficult. That's the situation we have to grapple with. Now, talking of 40-year or 10-year-old cases, can I just share, my lord, one small, because the officer is here, Madam Sabita, I'm forgetting her title, but she was the sub-judge at ASCA. So there were 5 40-year-old cases. Now I being the district judge, I always called up, visited ASCA, called up, what are you doing? And I must say to her credit, sir, she was absolutely thorough in all those 5 matters. She could tell the history and geography of all those 5 cases. So much so that I completely knew about those cases. Now we decided on a case management sort of a thing. During my tenure, at least 1 case was disposed of. The other 4, I was told later that it was also disposed of within a year, all those 40 cases. Because we had a plan for each one of them. I think Madam is there. She can also say, Madam Sabita.
I think she must speak.
Yes, please speak how you managed to dispose of those 5 cases. And she used to come to Barampur to, yes.
My lord, there are more than 5 cases. I don't remember the exact numbers. First, I went through all the records. And if you read the record again and again, you will find out some way. For example, in a case, there was a compromise.
Thank you.
Mr. Jenna, that the problem you had faced, we were discussing it with that APP and the judge in question. So that what we are discussing, it is better that you call each of them and counsel them so that both feel confident. At the same time, the problem is dealt with in a better manner instead of so that they don't confront each other. So you should call each of them and discuss it. Complaining that
My Lord Pranam, I am SN Mishra, District Judge Koraput, my Lord. We are very much obliged to the Honorable Court that such a colloquium is being held. My Lord, the decisions we have been supplied with are really wonderful decisions, and I'll highlight on two decisions, my Lord. Firstly, that of Munna Pandey. It is an eye-opener, my Lord, really. We used to put questions to witnesses in civil cases, particularly in matrimonial cases, under Section 165 Evidence Act, to ascertain certain facts. But in criminal cases, I don't know, hardly anyone has ever asked a question under Section 165 Evidence Act. And that is really an eye-opener. Secondly, my Lord, in the decision, the Honorable Apex Court have discussed about the role of the defense counsel, role of the prosecutor, as well as the role of the presiding officer. One thing I must highlight with my learned colleagues in the district judiciary, my Lord, that the judge can even put the contradictions to the witness. If the defense counsel, because of inexperience or having a junior, omits to put those questions, the judge can put that contradiction to the witness as well as to the IO. And my Lord, another factor which often we miss is the examination of the accused person, medical examination of the accused person under Section 53A CRPC. Often, my Lord, we see the accused person in rape cases are forwarded to courts, merely being examined under Section 54 CRPC. That often arrested. They hardly examine the accused person under Section 53A. 53A contains more things, my Lord, particularly on DNA examination. So I request my learned brother, whenever such a case comes, please be little bit conscious about the examination of the accused who has been done under Section 53A and of the victim under Section 164A. My Lord, you are discussing about Section 41A CRPC. Another factor we miss often, I have seen, with regard to compliance of the Honorable Apex Court's decision at Para 11.5 in the Arnes Kumar case and also in Asfaq Alam case, my Lord. The observation, the direction is that Para 11.5, the decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of the institution of the case with a copy to the magistrate, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Madam, what happens in cases where the punishment is below 7 years? FIRs are sent, police do not arrest. We come to know about the compliance of Section 41A only when the charge sheet is filed. They do not do so well. So if we start emphasizing on the compliance of Para 11.5 with regard to the communication not to arrest, not finding the accused to be arrested is something different. Not arresting the accused by virtue of Section 41A is something different. So, my Lord, if we insist on the compliance of Para 11.5, I believe lot of problems will be over. That was my submission, man.
Thank you. Anybody else? Yes. Namaskar. My Lord, Honorable Chief Justice has asked. Please, Mr. District Judge. My Lord, Honorable Chief Justice has just asked us to be very careful while framing charge. That has already been incorporated in Rule 83, amended rules of GRSU. Most of us are trying to follow it, and we are following it. And situation may improve in the near future. But what Biswajit District Kandrapada has said just about the problem the magistrates are facing at the stage of investigation. But those cases which have been, which should have been 323 cases, those have been, in those cases, final form has been filed under section 307. The magistrates takes cognizance. We are not, we have also taken cognizance during our magistrates period, but the magistrates are also taking cognizance of those offences. Those cases finds place in the sessions business and we frame charges, and those cases then go to this stage of trial. But in my long, in my this journey of about 25 years in this judicial career, I have never come across a particular, any particular case where those cases where the injured says that I do not know, I have not been beaten, I have not been assaulted, and those are very those are compromised cases. 232 CRPC have never been in Odisha. We never resort to 232 CRPC to acquit, pass an order of acquittal in those cases. We then come to ask the defense to come with his defense witness and write a judgment of acquittal. So if those cases are to be dealt under section 232, then most of the cases which are not required to go to the stage of judgment can be taken care of at that stage. But in that case, my prayer to the Honorable Court that in that case, some yardstick is to be given to the officer so that he must not lose by yardstick in that process. No, man. No, man.
232 same yardstick is given. I may have disposed of many such cases in Balesur. I think my Mr. Satyanarayana Mishra is not there.
232, my lord. 232.
Yes, yes, sir. Four days were given.
No, my lord. 32 there is no yardstick.
232 thila na?
No, like.
Check up it. Then we'll have to check up. ମୁଁ ନାଇଁ ନା 8 ବାର ମୁଁ ଜାଣିବା ଭିତରେ 232 ରେ ଥିଲା ଏବେ କଣ ଚେଞ୍ଜ ହେଇକି ହେଇଥିବ ମୁଁ କହିପାରିବି I think Mr. Satyanarayana Mishra could have thrown light on it because he was also in Balesur. Yes, Mr. Sharma, are you aware? When we had newly joined, probably it was 232 was for 4 days were given. Do you remember? No, what controversy? Controversy kon? Yardstick to daba controversy kon?
Says yes, it will yardstick.
Not
Some
given.
says no.
Nothing.
That will be changed. That will be changed.
That we will see. We'll see.
Another issue, my lord, in case of
I think registry can help us here. Please find out. Please find out.
Another case, my lord, in cases of civil cases. In civil cases,
Mr. Mishra, just a minute. Can you please inform the House whether I think when we were at Balesur, in case of 232 orders, I think 4 days were also given as yardstick. Yes. 4 days were given for sessions, disposal sessions, on contest 4 days, and for 232 also 4 days.
My lord, for contested disposal, we used to get 4 days.
yes, my lord.
But this is being treated as one uncontested disposal.
No, that requires to be changed. That requires to be changed. Actually,
And that
It's a- it's
and
a
that
proper-
232 disposal is to be made, my lord, in the order sheet itself. As we dispose of an acquittal under section 320, subsection 8. That
No,
shouldn't be the judgment.
I may be wrong, but we'll check up. We'll check up.
Because my view is tentatively is that is after full completion of the trial only we reach to the 232. That
My lord,
before, yes. Some,
I think, my lord, before asking the defense to enter into defense.
no, that is why that already evidence of the prosecution is recorded.
Yes, my lord. Yes.
That is why. So the trial part is almost substantively over. Okay.
Another issue, my lord, in civil cases. In 2021, my lord, Honorable Supreme Court in Rahul Shah case has asked the executing courts to dispose of execution applications within 6 months. That is not possible at all. One suggestion I may place before the Honorable Court that if in cases in stations like Cuttack, Bhubaneswar or heavy stations where there are so many execution cases, one executing court specially can it be designated to deal with those execution cases, so that
Mr.
that-
Misra, sorry to interrupt. Yes. If it cannot be disposed of within 6 months, you can extend the time, recording reasons. So you cannot take exception to dispose of within six months.
no, my lord, I am not on that.
Yes.
I am not on that. I'm
So
saying
that can be looked into. That is a separate aspect.
yes, ma'am.
But if a presiding officer so desire and he or she takes the initiative, I think there is no difficulty in disposing of an execution case within 6 months. There are a lot of procedures. Yes. But how to deal with a 47 application, how to deal with other applications, procedure have been provided and provisions have been made in Raul case. So that has to also be looked into. Yes, establishment of a special court or a separate court is a different aspect also. Yes.
I am saying from my experience, I was the principal sub-judge at Cuttack. So I found it very difficult to deal with the execution officers. Whereas 4 to 5 other additional sub-judges are there, they could have been given charge of that execution applications. That is my opinion.
You mean to say take up too much time for which you are
Yes,
not
my
able
lord.
to
Yes,
devote?
yes,
That
ma'am.
any
Yes,
other
ma'am.
officer takes it, may make up,
Yes,
lead
yes.
to speedy disposal.
yes, ma'am.
We have noted your point.
noted. We have noted.
Justice,
You have noted your proposal.
after all this. No, just
After all this-
experience as a bail.
For all this
Yeah.
deliberation. I'm dealing with bail application. I'm not finding it in any difficulty.
Sure.
All pending matters I'm trying to finish up within 10 days. So it's all your attitude as a judicial officer. There are so many things in the books. And most of the times I find that we are not using the armories that are pointed out by a lot of Chief Justice. So we have to be committed to the cause. We have to deliver. My view is simple and very clear, and you all are having vast experience. I did not teach you what to do. So you have to deliver, and you have to committed. You must be focused. It will. Okay, battery of like.
Yes.
So the things only. So without any fear, you have to deliver. You have to decide cases because all you know. Only one angle. Bail application is only one angle that you have to see. I fully agree with my lord the Chief Justice that while examining, law is very clear. 437 says that there are judgments starting from Arnes Kumar, Satyendra Singh until, and this last one is Asfa Kalam. So it lays down, it gives you that confidence. You can overcome after going through the judgments. You can gain a lot of confidence that Supreme Court is insisting that you grant bail in cases where it is punishable up to 7 years. And of course, depending on the nature and gravity of the offense. That's what I'm following. I've been able to dispose of cases. So you have to be right. You have to leave behind that fear and try to dispose of as many cases as possible. That much only. And so far, as judicial officers, I need not tell you, I have been telling you, but I'll tell you from the lawyer's perspective. As judicial officers, from the lawyer's perspective, what the lawyer expects. There are 3 things, according to me, because with my 28 years of practice, that a judicial officer, he must be disciplined, well-mannered, must give a pleasant hearing, he should behave properly. So these are the 3-4 qualities while you must maintain. Whether you are allowing the case or dismissing the case hardly matters for a lawyer. So you have to follow all these things. You have to be disciplined. You must your behavior must be good. Can't behave in a very rough manner, rude manner to the lawyers. Give them a patient hearing. Patient hearing doesn't mean that you will go on hearing, because you have to cut short wherever it is required. Give them a hearing. You can very politely, with good humor also, you can tell them, no, you are exceeding your limit. So you are the master of your court. You know how to control your court.
That is the act of court
Ah,
balance.
Right. So you have to control your own court. I need not tell you with all your experience. These qualities you have to keep in mind. And at the end of the day, the goal is same for you, for us to retain that public faith in the system. We have to deliver. We have to behave properly. We have to discharge our duties to the best of our ability without fear and favor. If you are afraid of something, then I am sure you will not be able to do justice to a case. So leave that fear behind. You are getting so much of support from the Honorable Supreme Court as well as from our Chief Justice, from the judges of the High Court. So go ahead, do your job. There's no difficulty, and all those difficulties like not getting reports, the police is not cooperating, 41A. You have every power under the statute. You know how to tackle all the police people. Tell them. I'm talking to 3 days back. In one matter, I granted anticipatory bail. The lawyer came before me. He said, although anticipatory bail has been granted, they are now forwarding. Immediately asked the additional standing counsel to call report the superintendent of police to be present before the court at 5 o'clock, along with the IAC. They were there. I asked, what is this going on? Then they said, no, it was not communicated. We have already complied with the order. You have the power. Please exercise. Leave behind that fear. You have to deliver. You have to regain that confidence, that public faith in the system. That much. Thank you.
And taking a cue from Justice Mahapatra, administration of justice also includes administrative power of the district judges. The pure psychosis that we have talked about, that should be avoided. That should percolate to the officers of the district also. The district judge has the onerous duty and responsibility to percolate that feeling to the judicial officers, also the administrative officers and staff. Because they are the guardian of the district, and that pure psychosis should not be there with the judicial officer and staff, that what our district judge will say if I do it, what our district judge will say, the district judge may take it as an exception if I pass this order. That should not be there in the, that is the duty of the district judge to create that feeling. So I request Justice Raman to speak few words.
I would only say, as all the judges have said, and you also understand that there is some hesitation in passing bold judgments or taking bold decisions. We have to take decision, and that decision is always subject to scrutiny by higher courts, higher authorities. So never take that in a negative sense, but to realize that there is a mistake committed and that mistake is rectifiable. So this much I would say, that none is infallible. None is infallible. So perpetration of error or mistake is no heroism. So we have to take a call on that, and we have to rectify ourselves and take all approaches given by higher authorities or higher courts in a positive sense and act according to that. That's all. Thank you.
Thank you.
Yes, CJMs have not spoken anything except Ms. Savita. They should say something. What are they?
No, the Chief Judicial Magistrate also may share their experience, the problems which they are facing, and if some innovative ideas they have adopted to sort out any problem, that can be shared so that it will be beneficial to one and all. Before going to that, just 2 days, 3 days back, the Learned Special Judge Vigilance, while recording the accused statement, has put questions on the 161 CRPC statement that witness has turned hostile. Most unfortunate part is that 161 statements are put in the accused statement and answers have been sought for. So this kind of mistakes, if at the stage of special judge vigilance would do, then it should be corrected as quick as possible. And at your level, I would request the Learned Chief Judicial Magistrate and the district judge to have proper coordination, have an interaction, and have a discussion what to do, what not to do, and what are the how the evidence is to be recorded, how the advocates are to be managed, in how the court decorum is to be maintained. All these things, like a elder brother, please guide them, so that because many young officers are coming after passing out 5 years course, they have virtually no legal profession experience. They just become successful in the OJS exam and here get the training, of course, for 1 year, but that is not sufficient. So many things are required to be taught to them. And if you, as a elder brother or elder sister, just give some time for them, and they will definitely improve, because they are all good students and they have performed well. And it just requires to share your experience. All right, we just want the Learned Chief Judicial Magistrate to speak up.
Mr. Acharya, please.
My Lord Chief Justice, my Lord Honorable Judges, Honorable District Judges, and my colleagues. Myself, Basudev Acharya, CJ Mayurbhanj. One problem I face of the times at Baripada, Mayurbhanj. So the cases are being transferred from court to court, and there is lingering of cases. Only the cases are pending in the statistical figure. They are not being disposed of only due to the absence of judicial magistrate. Because once they are posted for only for 3 months and they started working, they are being transferred. That is the main problem we are facing there.
But this cannot be the general feature. This is happening in certain particular district. Will take note of this.
My lord.
All right.
Obli.
I have a question to you.
My lord.
Do you receive the quarterly reports from the Juvenile Justice Board?
Yes, my lord. Quarterly, I inspect.
No, I am asking you. You are not inspection. Do you receive the quarterly report from the Juvenile Justice Board?
My lord.
Are you keeping the tape that whether these inquiries are being completed firstly within 6 months and
Yes, my lord.
extended to 1 year?
I am. Yes, my lord. I have
But
also talking with the.
some of the districts, I find this is not being done.
No, my lord. At Mayurbhanj, I am doing, and I am also talking with the presiding officer who is registered civil courts.
The power actually is there with the Learned District Judge to transfer particular case from one court, and if he is judicial, to give it run.
And my lord, CJM can also.
His power is there.
Yes, CGM can also do it.
CGM can do it. So you can do it. There is no problem with that. So.
Yes.
No. All of them will be done.
I could shoot before transfer.
What is happening, sir? Two or three magistrates will be there. They will be transferred in one.
How the case will
Again, that will come back to STJ.
the transfer of the
Those things.
Suppose one case, one magistrate is posted as second class. Suppose that what he is pointing out, that magistrate has been now become the first class magistrate. Let us say. He has dealt with that case to a up to some extent, a great extent, let us say. So, but for the absence of the magistrate that is pending there, which could have been disposed within 1 or 2 days or 3 days. So what can be done? What is telling that such type of cases which are there, can it be just transferred to his the other court? Suppose he becomes the first class magistrate there in that, or
If he
that-
will continue the first class magistrate, he will continue. the
that
trial.
that he's telling that.
He can continue the trial. That is the problem. He's getting transferred from the station. Out
No,
of
no,
the station.
station, that's a different.
Please tell your name first.
I am Ajanta Sadangi, District Judge Malkangiri. If a magistrate is being transferred from the justice, no further magistrate is being posted there, my lord. And the case is running and only the CIS is compliant. And after some time, on being asked by the decision, the CJM is transferring some records for trial and disposal to the by the SDJ. And the problem is that the seat is never filled up and the judgeship is not totally equipped with the officers.
That is some problem is there.
No, this is a serious problem. I have noted down it.
My lord.
Serious problem because we are not getting sufficient number of the judicial officers also sometimes.
My lord.
All right. Yes. Exactly. Why this should be a problem? Because the provisions of this 299 and the section 33 of the Evidence Act is very clear which category of the witnesses can be examined in absence of the accused person. The categories are already available in section 33 of the Evidence Act. Others you cannot examine. You have to pass first an order confirming these are the persons whom we are going to examine are falls in that category. Otherwise, your recording will not serve any purpose in future also. You just study section 33 of the Evidence Act properly, then you file the answer there.
Are you saying they are not able to do it because they're not aware how to follow those provisions? If that is there, you have a discussion with all your magistrates and advise them and help them accordingly. So that if they have any doubt, they'll come to you, you'll advise them. So the provisions are there, it has to be followed. If they have any doubt or you have any doubt that they are not doing it, you advise them.
Please come up. Please, don't. You have come covering so much of distance. We are here. Please share your experience, what good things you have done, how you are tackling with the, or having relationship with the bar, how you are maintaining your court cleanliness, everything you can. All these are part and parcel of this administration of justice. You can share your experience so that others can also know it. They can also improve. Right.
Yes. My lords, my lord, currently we have vulnerable witness deposition center only at the headquarters. I have prayed the honorable court to establish such a center at the stations where we have independent ADJs.
Mr. Misra, problem is there. The you know that I'm the chairman of that PWDC. So much of fund has been given for this entire infrastructure for recording this fund. We are monitoring and we are calling for the reports from the each of the district, and Mr. Akhil is there. He's also it has improved. The recordings in the centers, BWDC center has improved. But still then, unless we show the performance to be greater, we cannot ask the state government to give us, because some crores of rupees funds are necessary. So to establish in all the periphery, all the outlying stations, those things. You are right that some cases are pending in those cases which are to be also recorded. But if the victim statement, at least that can be, suppose I'm giving an example. Let us say in Champua, some cases are there, and the evidence of that victim is to be recorded in the BWDC. That can be done in Kemujar once the witness is safely brought here. That can be done here. That is no problem in that. So for the time being, if it is managed, once we show that these are the districts in which more number of witnesses are being examined in VWDC center, and these are the outlying stations in which this sort of facility is to be provided. We can impress upon them to, it's question of fund, nothing else is there. So try to manage, we'll see, we are conscious of that. In view of the Supreme Court decision, it is to be done also in all those cases. But you are right.
My lord, my humble prayer is that now the Honorable Court has provided also with sufficient funds. It is a matter of having the systems. If the Honorable Court so permits, my lord, I believe we can establish such functional systems in those stations. If we can go for the systems which we have currently in the district headquarters, that may not be possible, my lord. But still, I believe we can have.
We are in support of your proposal.
My lord.
We have no difficulty in doing that, but we have to study how much of the additional fund will be involved, because we going to the further level down to the periphery. That will, if it is permissible within our fund, then we have no difficulty in establish it. Or otherwise, temporarily also we can permit you to establish for the time being if a proper infrastructure is developed. And Mr. Costume covered, you just yes.
Can highlight this, please. Please.
Not like a remote point evidence recording. It has its own rule.
No. You could not follow his question. He says the similar cases which are pending in the district headquarters are also pending in the outlying, additional session judge or the special judge's case. They also require the similar kind of infrastructure. So that we cannot say no to that requirement. We only know our restraint or the problem with the finance that we will look into how much we can do.
Actually, we have a structural planning. It cannot be allowed to function in a temporary way. It requires infrastructural.
Right, he is right. Justice Geeta Mittal, who is now supervising everything as per the direction of the Honorable Supreme Court. He was the ex-Chief Justice of Jammu and Kashmir High Court. He has been specifically appointed. He has framed that how this BWDC center, what should be the infrastructure, cannot compromise. He's looking at every aspect. Temporary arrangement, if that can be done at that level, that means then can only, because at least 3 rooms are required. One is the recording of that evidence, that is judges. The other is that rest room, that means witness. The other is the recording room. So 3 rooms at least required. Separate passage for the, all these, all you all know. So if that facility we can provide, how much fund will be required for that? So that thing we cannot compromise your cost short. Whatever you're telling that with small fund you can manage things, but once those things are not there, and once it is questioned or it is brought to the notice, sir, these facilities is not available. In spite of that, the High Court is allowing the recording of the evidence in this center. It may create some problem. That is what is.
My
Just
another
one thing I
prayer.
say that we have to relook into the issue.
My lord.
We have, but we have to relook into the issue because there is a very good point in that that they are facing their difficulty. We do not need the Supreme Court decision is a mere guidelines. We have to also address our local issues as also. We will look into that issue.
My lord.
Sir, Pranam, I am Aravind Patnaik, Judicial Moirun. Sir, I just want to highlight 3 points. Sir. We are not giving proper attention to our libraries. Our libraries are full with old books. Every justice should be directed to purchase at least books from 1 lakh or 2 lakhs. Specific amount should be allocated for each library, number 1. Number 2, sir, a compendium of general orders and circulars. The last published general orders and circulars, that is of the year of 1988. We need a compendium. The high honorable judges, those
I
circulars.
request the Registrar General to just take note of this.
At least that may be published in
Both
electronic mode.
regarding the fund for the purchasing books and the publication of the.
I think 3 books, 3 journals every month is given to each of the, right? One is, I think, OCR, the other is OLR, and I think CLR,
Not in
right?
bound volume.
Right. And
Only because
no, why
there's
bound?
100
Just, is it bound volume or it is coming every month?
loose volume, but you need to bound it. Bound it. The problem is they are asking 180 rupees. We are,
Then SCC online. Are you getting SCC online or not?
sir,
So as such, you are getting 4 books from the High Court, from the,
that our test books are also required, sir.
yes,
Test books.
test book in the, if whatever books you require, if it is not there,
Not
and you
test
have
book,
not found in the district court to purchase those test book, you can write so that to the registry, and appropriate arrangement can
No,
be
sir,
made.
we are getting OC, other contingency for that. But attention should be given by the all
Yes,
judges.
yes.
Purchase books should be purchased.
Let's see, I want to permit me to say something on this, sir. Sir, one is, so far as the compendium is concerned, sir, in the last discharge conference, it was the resolution of the Honorable Court that the earlier compendium, which is out of the print, that is to be uploaded in the, till 1988, it is to be uploaded in the website of the Honorable Court. It has already been done. Then another instruction was therein that the compendium after 88 is to be prepared by the High Court, and that is to be placed before the Honorable Court. And again, it will, now the registry is working on it. Within a month, we are expecting that we will come with a latest compendium after 1988.
Okay.
Then
Sir,
let's,
one thing I would like to add to what Mr. Patnaik has said, I'd like to flag one small issue. While you have a library and you have some books, you can make use of a software called e-Granthalaya, which is given free by the NIC, local NIC. I did it in law department. I had begun it in Ganjam, but I don't know what happened to it. There, government, NIC gives it free. You can talk with the local NIC man so that whatever books and journals you have, at least you have an inventory of it. It will be, that software is very, it's very effective. So whatever books you have, you can try that. I think Mr. Misra has done it probably. Yes.
let's see the other issue what District Maribons has raised, sir, regarding purchase of the law books. Let's see, in the current financial year, also in the last financial year, we have sufficient funds under contingency head. There is no head in the government budget regarding purchase of books. It is always purchased from the contingency. Let's see, earlier in the earlier years, we are unable to give allotment of even 10 lakhs to bigger justice. Now we are giving in crores, not in lakhs. So it is the district judge to decide what books is to be purchased. In fact, we are receiving in the registry the complaints from individual officers that our district judges are even not giving the bare acts to perform the duties, their day-to-day duties. So here I may have a request to Honorable Court that the funds given, sufficient fund given, if required, we can give further fund. But sufficient new books to be purchased for every district library, so also to the Taluk Courts library. And every court should be given specific books which are required, and immediately it is to be attended when any requisition is received from the respective courts, particularly the judicial officer, those are interested to go through the book. That is my request here in this house. And fund is not a problem, and they can purchase from out of the contingency.
Fund is always available. Contingency fund is always available. They have to take a call on this. The district judges have to take a call on this. They have to decide which book they have to purchase for the library.
One case, I just called for an explanation from the learned additional session judge. The minimum punishment prescribed for a particular offense has become 10 years from a particular date, and that occurrence took place after that. He has awarded 7 years punishment. There is nothing in the act that it can be reduced from 10 years minimum to that. I asked how this occurrence has taken place on this particular day, and from that day it has been changed to minimum punishment is 10 years. How did you impose 7 years punishment? And the explanation is more funny, that in the district court only one IPC was available, that was of this year, and that prescribed punishment.
The last DCS conference also, this issue was taken up. I think regarding use of that contingency fund. In most of the cases, it is found that they are returning the money, 50-60% money are not being paid in the developmental work or for the purpose for which it is sent. So you can always.
Of the registrars and the court managers, I was given the chance to interact with them on fiscal management, infrastructure management. Sir, the statistics of this financial year is the contingency expenditure, including the expenditure of the outsourcing agency, is 27% only. We are at the 6th month of the financial year. So we have a request. Yesterday, I have also made a request. We have also the allotment which was given to the district judges. Other than that, we have also sufficient funds available in the High Court with her. If any further requisition will come for expenditure, we can give in huge amount, not in small
That
amount.
can be taken care of. If requisition comes, that can be taken care of. But the funds available with them has to be utilized.
Funds are there with you. Utilize that. Books are bare minimum necessity. How can a court function without the books?
During my last visit to Sundargarh, some of the advocates complained that the e-library provided to them is not functioning properly. Whether district of Sundargarh has visited that? No, what working? How it is being used? No, whether there is any difficulty? Then why the advocates come?
So much of fund has been spent, right? So there must be something on record that how many advocates are utilizing that. Otherwise, no purpose should be served. So you not only that it is there, but you should motivate the young, at least young lawyers, to go and use the library. You should say that find out this decision. Suppose in your courtroom, a discussion is going on, and junior counsels are there. Ask them, I am giving, entrusting you, you find out the decision to the e-library and search for this, you find out. This way you can motivate them. Properly utilized, right? So what Mr. Mahapatra, Justice Mahapatra was telling, that is exactly that there is some kind of complaint. Look into that. What is the, go and visit, sit with them.
exactly, my suggestion is that at, at the end of every month, the district judge or the registered civil court or the judge in charge should visit the e-library, see that how it is being, how many advocates have used the e-library and how it is being utilized, whether there is any difficulty. I think there is a clause in the guidelines given to all district judges that they should furnish a report, timely report that how it is being utilized. That the when a district judges should look into that. That is my request.
We have already discussion on few topics, but we want also discussion from your respective district, how the bar members are cooperating, what kind of problem you are facing from the side of the bar, how you are dealing with it. That aspect also, there may be some judicial officers may tell about that, so that
My lord, I may permit. In administration of justice in district judiciary, the role of the Group C employees, who are the chief ministerial officers or other junior clerks, is very important in maintenance of records, registers, etc. So in Kandhamar, we have started about 6 to 7 months back. We have started a meeting of all the chief ministerial officers, the outlying stations over VC and the headquarter stations physically, so that and by a committee comprising of registered civil courts, CJM and the CAO, so as to monitor their progress in all these activities. And this has given us a wonderful result, as registers are being maintained properly and records are being there, removing the doubts, and we are doing it. This is my experience in Kandhamar.
Have you shared it with your good practice with other districts?
No, my lord, I have not yet said.
Please do it.
All right.
If, good practices should also be shared and it should be followed.
Yes.
Exactly.
Yeah.
That although most of the decisions are accused related, but I feel that before somebody must be victimized. And this definition of ethics, and for December 2009. Prior to that, there was no provision, scheme of government of any state of India about victims of crime. So they felt that most of the courts are not recommending for compensation. So when we are expecting the result that is in capital or conviction, my view that some column with the victim has been properly compensated. Unless the victim of crime is properly compensated.
no victim compensation scheme is there. Offenses have been categorized in what sort of offenses, how much is or she is entitled to get. And I think most of the district judges and the at the level, even the magistrates are doing it, and legal services authorities are there where this compensation are paid also in phase by phase manner. So what is the problem you are facing?
I see that there are, if I am in developed state, that the people are not aware. These people are first time with the police are not aware. Most of the courts are also not referring.
You should bring the head.
You try to convince them.
Yes, I used to ask the report from DC. They case of the victim, they can know, they make them silent about their financial condition of what, how they, what kind of benefits can be expected. That is the new practice I am also adopting. And my request is that there must be a column to show in the register whether the case ends in acquittal or conviction. At the same time, whether the victim has been appropriately compensated.
It's a good thing. It's a good thing.
And second thing, most of the witnesses, they do not get partnered with the cash and with the process established secondary. That can be raised to 5,000 or 10,000.
Which one? Witness pattern.
Witness one.
It depends upon the distance, I think he travels and he gives the, that is verified of support.
Oh, is it cash in hand to raise the limit of? We'll look into that aspect. We'll look into whether it can be enhanced to the
That was
10,000.
also discussed in the last discussion.
Ah, that was there also.
That
Possibility
needs review.
resolution was taken.
That needs review.
Justice Mishra, if you want to say something. No, that's not closing. If you being the you were in the district judiciary for some time, you can throw light on these certain problems better.
Yes, sir. A lot has been said on the problems. I will not harp upon the problems, sir. And I happen to be an odd man out here. But I am, sir, hybrid. Like we are doing hybrid hearings, we are a hybrid. Because I was a lawyer for 13 years, district judge for 11.5 years. So I have seen both.
We would also like to hear from you.
No, I have only three limited points to make in this colloquium. First is the way Honorable the Chief Justice started. You know, he started with an apology for calling you all on a Sunday. And that tells a story. He is the highest judicial authority of the state. And when he orders, everybody has to come. There is no doubt about it. But he started by expressing apology. So that tells a big story. And what story? I am reminded of a book that I'm presently reading. The book is titled Ego is the Enemy by Ryan Holiday, an American author. It's about, you know, how big top level persons have fallen prey to the machinations, I would say, machinations of their ego and have gone down. This takes me to the topic that I wanted to say, having been a district judge at a relatively young age, when there were some officers who were also senior in age to me, though ranked lower in the gradation list. So there is always a challenge as to how to deal with them. Now, the district judge, according to me, is a father figure. So jokingly, there was a lady officer who was on the verge of retirement. Mr. Jena will stand testimony to this. I said that, Madam, you are my elder daughter. I am your father, even though I may be younger than you. But the point that I wish to make is, this is joke apart. You see, when you become the father figure, even the junior most officer in the cadre may have something to speak, to say, to share, but will not be able to do unless you have that kind of an attitude. And when I was a district judge in Keonjhar, Mr. Jagdish Mati, who is the district judge of Dhenkanal now, he was also present there. A lady officer who was subjected to a bit of harassment, but she couldn't say, she didn't muster the courage to bring it to my notice. And in between the district judge and that officer, there was a hierarchy of officers. I think Mr. Pranab Rautra was also there. He is also aware of it. So I couldn't know. I was requested by them that you please listen to her. I never knew that she had a complaint. But when I called the lady officer aside, she told me certain things, which of course I reported to my administrative judge. I was shocked. If I would have maintained a big distance, saying that I'm occupying the exalted seat of the district judge, so she would never gather the courage to come and tell before me. So, but on the contrary, if I'm like her father, whether age permits or not is a different matter, but a father figure, then she will open up. He or she will open up. So that is how you run, as my Lord Justice Sahu has also said, that we must work like a team. This is one aspect that I wanted to say. The second thing is that as administration of justice, Mr. Misra pointed out that it is, he has taken a very good initiative, and Mr. Rautre also has taken an initiative by interacting with the Group C employees. You see, they are our backbone. They are the support staff. That is why we call them support staff. Imagine if they don't do their work, what will happen to us? So, but then how do we deal with them? We can do it both ways. Supposing we are too lenient, then they'll take advantage over us. We have to use the rod sometimes. But then the human element cannot be taken away from the equation at any point of time. Please keep that in mind. In exercising power, we must know that we also have a lot of responsibility. So this responsibility, we must keep in mind always. That person, his family, they're all dependent on our whims and fancies, as it were. But then we have to be, if we really call ourselves judicial officers or judges, then we must always, our actions must be tempered with kindness and compassion. Not that I'm saying that you must spare the guilty. We will be very, very ruthless when it comes to, seeing somebody commit a mistake, then we'll be very, very ruthless. By all means do that. But our behavior with them, how do we talk with them? How do we behave with them? And I tell you, news travels. What you do in a corner of Odisha will travel everywhere. Only because I am posted in an, according to me, in an inconvenient station does not mean that the High Court, you have fallen out of favor, or the vice versa. Only because I am posted in a particular station, which I perceive to be a sort of a reward, it is my mistake, sir. There is no reward or punishment according to postings. Please keep that in mind. And so don't allow your ego to climb. If your ego blunts your vision, it destroys your rationality. And if your rationality goes, then no justice will emanate. This is my, whatever little I have learned as a judicial officer. Now, another thing, just the last thing, which we have been discussing since long about the magistrates and the chief judicial magistrates. As I said, we are not agents of the prosecution. My Lord, Honorable the Chief Justice has said that we are not supposed to be umpires, mute spectators. We have to challenge them. You want me to take cognizance? Show me that there are materials. So this is what I wanted to say, share with you. You are all experienced officers. Some of you have held the highest position of a district of multiple districts. I don't claim to know more than you, but whatever little I have learned on the way is what I have shared with you. Thank you.
Thank you, Justice Misra.
Some lady judicial officers, please speak up one or two so that thereafter Honorable Chief Justice will sum it up. Please, the girls are performing better in the OJS examination. They are huge in number, so we hope that the lady judicial officers should also share their thoughts and their ideas. Please come up. Please stand up and tell something, lady judicial officer. Anything which you want to share, please. Please.
Yes.
Working at Chief Judicial Magistrate, but the great opportunity to speak before you all. Whatever my experience as a Chief Judicial Magistrate in my district, we are sharing very cordial relations with our district. Whatever issues we have, we are sharing with you. We are having a discussion in terms of all judicial officers, maybe the most and all the additions judges, everyone. We are trying to shut down the rest of our issue or in or regarding one thing I want to share, like we discussed, I discussed with my We are preparing the detailed figure, like what are the executions exactly from the last month of the year and what is the exact execution of warrant and signing of final form and the death reports in the month of August, how many death reports are executed and what is the next trend. So what we got a lot of cooperation even from the other administrations like police and the DOT, everyone were present. They are asking sometimes like, although there are execution of MPW, sometimes what happens, they are using somewhere. Because of that, they are not able to. So for our district, we have again, we have a listed total tendency of MPWs. So almost like 1,900 MPWs with detailed correct answers of all the accused. Last month, we have supplied it to and what we did almost 200 to 300 execution of warrants. That's good. That's good. So I think it's a great achievement for
It's right. Very good. Very good. Right. Very good. Very good.
Very good. Madam, another question. Are you satisfied with the infrastructural facilities provided like restrooms, toilets and everything? I hope that is up to the mark.
There is a team, there is a committee that is formed. Every day, 2 of the judicial officers, they are visiting the entire court premises and they are talking with the people who are keep the building.
All right.
At the same time, I want to share one thing more. We have again created a WhatsApp group in which I am representing my district from the judiciary. That is our chief CDMO, SGMO. So whatever is the issue, if someone is not coming for deposing before the court or any execution of order, any other issue, we are directly sharing it in the WhatsApp and the things are positively we are handling.
Good. So this is as regards the professional thing is concerned. I'm asking about facilities provided in the court, maybe your residence, security, for specifically for lady officers.
And outlying stations also.
And work environment and all that. Do they feel safe? Clean, safe, your house, your residence and everything, all that, you feeling comfortable?
Every court, I think there has to be a police person. There has to be a police person because many accused are coming. So whereas our staff are concerned, they are not sufficiently equipped to provide any protection to all in case of any accident. That is my personal. So for security thing is concerned, I think it has to be a bit more strong.
Beefed up. Okay. All right.
Did you talk it to the SP during senior officers meet?
Mr.
DPOs can
Mahanti,
also.
you know the 2 gangsters. So please see that the
So far security of courts are concerned, let me tell you, recently our Chief Justice, he has understood the importance of it and a new committee has been formed to look into that. So we will definitely be looking into all those aspects. So, chairman can be anybody, any of the brothers. So that's not the issue. Issue is their safety. That we are going to take up very seriously because we are getting reports of many such breaches. So what I suggest is in some of the cases where you apprehend in advance that there is a possibility, you inform, you tell your decision or you talk to the Superintendent of Police to provide the protection in those cases. You need not hesitate. As judicial officers, either through the discharge or you can immediately report to the Superintendent of Police of the district that in these cases I am apprehending there might be some tussle between the groups or I am apprehending some sort of danger. So accordingly, they will provide the protection for that day or for that case or something of that kind.
Precedents are there that in the court compound.
Once you have to assess the threat perception and accordingly get ready for that. And otherwise also we are looking into the matter, will be coming up with some scheme so far safety and security of court.
I would request the Registrar General High Court to just elaborate on the recent steps taken by the High Court in these aspects.
My Lord Honorable Chief Justice, Honorable Judges on the dais, my brother judicial officers. Before elaborating the steps we have taken, I would like to brief that this is the matter received as in a judicial direction from the Supreme Court to take care of the security, including the CCTV matters in a judicial judgment. And basing upon that judgment, Honorable Chief Justice asked me to direct the DG, the Home Principal Secretary Home, to attend a meeting. This is also part of the judgment of that Supreme Court. Accordingly, a meeting was convened in presence of the Honorable Chief Justice and Building Committee Chairperson, Dr. Justice P.R. Swadhi. In that meeting, a huge gathering of security team, including IG Crime, DCP Bhubaneswar, DCP Cuttack, and many other AG, Additional District Director General of Police were present, and a detailed discussion on threat perceptions on our security system in the court, including that of the women, judicial officer staff. Everything was taken care of. And basically on that, we drew a minute, and we have asked at the first stage, we asked the DG to go for a survey. The entire police team of the state divided themselves and conducted a survey. And I hope and trust everybody have cooperated, all the district judges have cooperated, and we received that detailed reports, it's voluminous reports. Thereafter again we convened a meeting, and in that meeting we draw a minute, and we have asked the district judges to constitute a committee, not only in the headquarters but also in the taluka level court. And we have asked them to submit their constitutional committee by today. Once it is received, your lordship will place it, and further course of action will be taken.
My Lord, there was a meeting of the committee on 12th of September. I have already submitted, we have taken certain decisions with regard to the security points, and I have already communicated the decision to the Honorable Court.
In the High Court level, committee is headed by the Justice Aditya Mahapatra. So he will be looking into that, and you will also sit with the top brass of the police administration and the district administration. And whatever the follow-up action has to be required, that will be taken from this court. Or also, you will be asked to, at your level also, you coordinate this work so that the security aspects we can properly address. Right. That is the reason in the district level and taluka level committees are formed to just give the quick response to any issue, and in a long drawn matter, so the security can be a subject matter of the court administration.
Yes, my Lord.
Mr. Mahapatra,
Thank you, everybody. Now, this is the time to wind up the session. Today, we think that we are happy that you have deliberated your experiences, your problems, your suggestions also. From the, a duty has been cast on me to sum up the session, sum up the entire discussion. First of all, I draw attention of all of you, especially the district judges, with regard to the Article 235, which our Honorable the Chief Justice deliberated during the inaugural session. Every district judge should keep in mind the constitutional right conferred on them and the duties flow from that. That is not only the judicial responsibility and duty, but also the administrative duties and responsibility. So, so far as the judicial responsibility is concerned, adjournments are the most talked about problem which causes delay in disposal of the cases and dispensation of justice. So, as suggested, the officers, judicial officers should always keep in mind section 309 CRPC in criminal side and order 17 in civil side. So that has to be scrupulously followed and should be followed in its letter and spirit. Secondly, before framing of charges or in a criminal case or framing of issues in a civil case, a detailed hearing has to be done. It is not a mere formality. It has to be done to avoid unnecessary unnecessary protraction of the litigation, unnecessary examination of witnesses also. Section 309 CRPC has laid down how to be dealt with the adjournments in criminal cases, and Order 17 Rule 1 also deals with how to deal with adjournments. Order 17 deals with adjournment also. So that has to be followed and that has to be adhered to in its letter and spirit and ceremonious, so that before framing charges and before framing of issues, the presiding officer will be abreast of facts and the real issue involved in the litigation. Then the court management. Court management includes case management also. While dealing with the case management, the case management, quote and unquote, as suggested by Honorable the Chief Justice, has to be followed. We need to change our attitude to approach a litigation, approach a problem, approach a case. That traditional approach to a litigation has to be avoided, and in every case, the presiding officer has the responsibility to see that how the case is to be managed, how he has to fix his route, fix the timetable to manage the case. Mr. Misra was talking about disposal of execution cases. Yes, truly it is a problem. It is very difficult to dispose of an execution case within a period of 6 months. But in Rahul Shah's case, the Honorable Supreme Court has mandated that it should be disposed of within 6 months, failing which, while extending the time, the court has to assign reasons why it is being extended. If we have a proper case management, although not within 6 months, but in a quicker time, the execution case can be disposed of. Yes, we have already taken note of in certain matter, in certain places, a special court for execution to deal with execution cases needs to be established, because in execution cases, it is said that the real problem starts when the decree holder gets a decree. He has to face the litigation thereafter only. So we have already taken note of and will deal with the matter in appropriate forum. Now, the Section 165 of the Evidence Act, that is intervention of the court, has to be also followed. In certain cases where the court's intervention is necessary to avoid unnecessary recording of evidence, the court has to follow that procedure and to adhere to the provision. The court has the discretion, the presiding officer has the discretion to follow, intervene in the matter and pass appropriate orders in certain cases. Demeanor of the party has also to be looked into. Very little, it is being given a little importance, very little importance. But the demeanor of a party, demeanor of a witness is a vital aspect that has also to be looked into by the presiding officer. And the registered judicial is also requested to form a desk to deal with the various problems of the district judiciary while dealing with the matter. So far as the administrative side is concerned, the district judges are the guardians of the district. They, as stated by stated by Justice Misra, that they are the fatherly figure of the district, although the age does not permit that. But they have to act as a father of the or the parents of the all other judicial officers and support staff. They have to inculcate that confidence in the judicial officers and support staff so that they can open up. But as stated, a Lakshman Rekha has to be maintained. You cannot be so liberal so that the support staff will sit on your head. But at the same time, their problems, their interest has to be protected and has to be looked into. I have heard in my early days, in the practice, I have heard that the district judges were taking classes of the judicial officers because the subordinate, the officers who have joined recently by clearing OJs, they don't have any practical knowledge about the practice. As stated by Justice Sahu, that the training given in the Judicial Academy is also not sufficient to come up as a mature judicial officer and to deal with the issues. So it is the onerous duty of the district judges to have a meeting with all the judicial officers, like the senior officers meeting, and a separate meeting also with the support staff, so that they can open up and come up with their problems. As Justice Misra said, in the district of Ganjam, he had faced such a situation, and while discussing with the presiding officer, lady presiding officer, he was astonished that she was suffering. She was Keuzar. I'm sorry, Keuzar. She was going through such a trauma. If the judicial officers work under pressure with a fear psychosis and they cannot open up with the district judges, then there is no point in holding this colloquium. This colloquium is organized to communicate that they should omit the quote unquote the word fear psychosis from them. If you are acting rightly, you are acting consciously, you are acting diligently and in accordance with law, then there is nothing to fear. The district judges are also required to percolate this message to the judicial officers of the district so that they can work fearlessly as per their wisdom and conscience. Because our main duty, our principal duty is for dispensation of justice. the litigant should have faith on us. If the litigant does not have any faith on us, then we cannot justify our role in the judiciary. That if a judicial officer acts with fear, with a doubt in mind, and as to how to deal with the matter, then he or she cannot dispense justice to the litigants, to the poor litigant. Most of the in Odisha, 80% litigants are poor. So that passion the judicial officers have, not only passion, they should be well conversant with the law, the facts of the case, and to be prepared before the first hearing of the case. They have to read the brief thoroughly and prepare a note. They should also keep that note on the top of the brief so that the subsequent officer who will add on the office will, by seeing that note only, can know that what is the matter and what is the real issue involved in the case, so that his or her time will be shortened to deal with the matter, and he or she can formulate his or her way of procedure to deal with the same. The procedure as provided in CPC and CRPC Evidence Act, I think those may not be sufficient in certain cases. The court has to, within the four corners of the law, has to frame its own procedure, which is not contrary to the provision of law, so that to see that the matter is being dealt with effectively and efficiently. Lastly, this discussion and the points you have raised, suggestions you have made so far as BWDC is concerned, PATA charges are concerned, we have taken note of everything, and it will be dealt with in appropriate quarter. And I congratulate you and thank you all to have actively participated in the colloquium and shared your thoughts. Thank you very much.
Thank you, my lord. With this, we have come to the end of the colloquium on the subject of administration of justice in the district judiciary. I am sure that every one of us has got some positive takeaway from this colloquium, which will help us in addressing the bottlenecks in a very effective manner and perform our duties in a more efficient manner. Before calling it a day, it's my humble duty to express my gratitude and vote of thanks to each and every person who made this program a successful one. On behalf of the Honorable High Court of Orissa, the Odisha Judicial Academy, and this August House, I express my deepest gratitude, regards and obligations to Honorable Mr. Justice Subhasis Talapatra, Chief Justice, High Court of Orissa, and the Patron-in-Chief of the Odisha Judicial Academy for being the main sculptor of this program. It was His Lordship's idea that we conceived this program, this colloquium, and Lordship always gave me constant guidance, all support, all the breakups, everything. The idea of holding this interactive session, parts of its kind in Odisha Judicial Academy, it was all His Lordship's idea. On behalf of this entire house, Lordship, I express my gratitude and send my thanks. I also extend my heartfelt gratitude and obligation to all the honorable judges of the High Court of Orissa, who, despite their busy schedule, have been present here since morning. Though it's a holiday, they have been here to encourage us. They have actively participated us, and their enriched participation in this program has actually been very fruitful in answering many questions that we never could be able to put before the authorities. Thank you, my lords and my lady, for your gracious presence and participation. I am also thankful to Honorable Mr. Justice S.K. Misra and Honorable Mr. Justice Sivasankar Misra, who have joined us through virtual mode. Thank you, Lordships, for your participation and encouragement. And I also take this opportunity to extend my heartfelt gratitude and thanks to Honorable Mr. Justice Debabrata Das Judge High Court of Orissa and the chairperson of Orissa Judicial Academy and Training Committee, and all the honorable members of the committee for their constant guidance and good wishes. Thank you, Lordships. This program is successful only because of the participation of the honorable district judges, the respected chief judicial magistrates who have come from all the 30 districts of the state. I take this opportunity to thank each of them for being present here today and for their beautiful participation, meaningful participation, which has helped us in deducing many things, which will be helpful in administration of justice in district judiciary in a very efficient manner. I thank each one of you. Thank you, sir. Thank you, ma'am. I'm also thankful to Honorable the respected Registrar General, sir, the officers of the Registry of the High Court of Orissa, who have been constant help to me. So far as any program at Judicial Academy is concerned, they have always helped us in all possible manner. Thank you, sir. Thank you for your constant help. I'm also thankful to the Member Secretary, sir, of Odisha State Legal Service Authority for his kind presence here. I also take this opportunity to thank my team, the Assistant Director, the staff of Odisha Judicial Academy, who have made all the arrangements for today's program. Last but not the least, I extend my heartfelt thanks and gratitude to each and every person who has made this program a successful one. Thank you. Thank you very much. On behalf of Odisha Judicial Academy, I say goodbye. Namaskar. Thank you much. With these words, may I seek the kind permission of the Honorable Chair to declare the colloquium as closed. The colloquium is now declared closed. I request each one of you to please kindly join us for lunch. And we have arranged the group photograph for all of you. Please collect it from the help desk. Thank you.
Ready?